It's one.
I get the.
Yeah.
But then I can't.
The link, that's annoying. Oh, crazy
And then I
pants.
found that.
Yeah.
Crazy.
And then the alleged crypto scheme. Allison.
Well, the feedback would start and I would push the whole view. Okay. So, but we can't keep it muted. We're not able to. Yeah. Yeah.
That's 1, 2, 1, 2.
It seems a little late, sorry, everyone.
No, okay.
You good, Jeff? See how it goes. Yeah, we're good to go. Yeah. Yeah.
Okay, so you go back to.
Hear ye, State of Michigan Court of Claims is now in session. Presiding, the Honorable Seema G. Patel. All persons having business herein draw near, give attention, and it shall be heard. God save these United States, State of Michigan, and its honorable court.
Good morning. Please be seated. Welcome back. Call the case. It's 24-11 Northland Family Planning Center versus AG Dana Nessel et al. We are back for our 4th day of trial. Are there any preliminary matters before we need to begin today? Okay, then let's recall Professor Baghdadi. Yes.
Your Honor, should we put our appearances on the record?
Actually, yes, let's do that.
Good morning, Your Honor. Megan Kelly from Fort Carrington and Sutcliffe for the plaintiffs. Molly Plain from the Center for Reproductive Rights. Miller from the Center for Reproductive Rights.
Morning, Your Honor. Alexandra Willingham for the plaintiffs.
Good morning, Your Honor. Allison Epperson from Orrick, Carrington, and Sutcliffe on behalf of the plaintiffs.
Good morning, Your Honor. Rachel Miller from Orrick, Harrington, and Sutcliffe on behalf of the plaintiffs.
Good morning, Your Honor. Deja Tillman from Goodman, Herbertson, James, PC on behalf of the plaintiff.
Morning, Your Honor. Assistant Attorney General John L. Huddle appearing on behalf of the intervening defendant.
Good morning, Assistant Attorney General Christopher Braverman on behalf of Director Marlon Brown.
Good morning, Your Honor. Assistant Attorney General Rebecca Abuna on behalf of Dana Nessel, Attorney General.
Morning, Your Honor. Neil Giovanetti on behalf of AG Nessel.
Good morning, Your Honor. Brianna Listerman, Assistant Attorney General, here on behalf of AG Nessel.
Morning, Your Honor. Assistant Attorney General Daniel Ping on behalf of Defendant Hertel.
Okay, thank you. Good morning. Now, if plaintiff would like to recall the witness, we can recall Professor Baghdadi. Okay, let's re-swear the witness from.
You swear to affirm on the county of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
Good morning.
Good morning.
I'll just go right into it. All right.
Professor Baghdadi, could you please put your full name on the record also for, just for.
Sure,
people
shall I spell it?
Sure.
Okay, my name is Kate Spector Baghdadi, which is KAYTE SPECTOR hyphen BAGDADY.
Thank you, Your Honor. Professor Spector, you agree that it would certainly be reasonable for a physician to reference the AMA Code of Medical Ethics, correct?
In what context would they be referencing it?
To know appropriate ethics.
Sure, yeah.
Okay. And isn't it true that the AMA Code of Ethics is a reliable code for informed consent for a doctor practicing medicine?
Yeah.
Okay. And isn't it true that pardon me. Yes, isn't it true that a generally agreed upon definition of what needs to be involved in an informed consent conversation includes disclosures about the diagnosis or prognosis of the underlying disease or disorder and information about the risks, benefits, and alternatives to the intervention that's being discussed?
My only addition would be relevant or material.
Okay, but that is a true statement, what I just said.
As a good definition of informed consent, yes. And
Okay.
then most courts add relevant or material.
Okay, thank you.
Mhm.
The information that has to be disclosed, you mentioned included alternatives. Does it also include having no intervention at all?
Yes, sometimes that is an option for people. Sometimes it's not.
Okay. You agree that it's consistent with standards of informed consent to discuss I'm sorry, we already discussed that. You agree that one alternative to some abortions would be live birth.
I agree that that is one alternative to some abortions, yes.
And you agree that if the patient is interested in live birth, information regarding public assistance might very well be relevant to her, correct?
Sure, if the patient would like information about public assistance, that would be very reasonable, yes.
And you also agree that a reasonable alternative to some abortions that might result, a reasonable alternative to some abortions that might result in a live birth would be adoption, correct?
Well, so that's sort of a double-barreled question, but an alternative to an abortion is not adoption. It would be live birth. But then if somebody has a live birth,
Yeah.
yes, adoption is one of those options.
Okay. And isn't it true that a patient doesn't know if information is relevant to her unless she knows what the information is about?
I'm sorry. Yes, I mean, in order to understand alternatives, I'm sorry, could you repeat that one more time?
Isn't it true that a patient doesn't know if information is relevant to her unless she knows what the information is about?
So, sure. Yeah.
And isn't it true that a patient can be certain about a decision because the patient thinks that her choice was the only option?
Well, so in philosophy, we wouldn't consider that an autonomous decision if the patient is being coerced or doesn't understand
I'm
choices.
sorry, that wasn't my question. My question is, isn't it true that a patient can be certain about a decision because the patient thinks that her choice was the only option?
I guess, yeah.
And an abortion removes the fetus from the uterus, correct?
My understanding is that it's not always a fetus when you get a medical abortion. It might still be.
Or an embryo?
Or an embryo.
Okay.
Yeah.
But in the case of a fetus, right, shouldn't a patient with, say, a 10-week-old fetus with no diagnosis of abnormality, shouldn't that patient know that her fetus that will be removed from her uterus has well-formed fingers and toes and a heartbeat? Shouldn't she know that?
No,
You don't think so?
I don't think that that's relevant to the decision that she's making. It's not a risk, benefit, or alternative to an abortion.
You testified that there's no evidence that ties waiting 24 hours to improved informed consent, correct?
That, to my knowledge, yes.
Right. Does evidence suggest that some women, after a 24-hour waiting period, do not proceed with abortion?
If there's literature on that, I don't know it.
So you don't know if that ever happens?
It's hard to prove a negative. I can't say it never happens. But sorry.
I'm sorry, that was my fault. I shouldn't have interjected. Please finish.
I can't with any assurance say it never happens, but if there's literature that actually tracks how many women do not get an abortion after the 24-hour wait period due to reconsideration of their choices, I don't know that literature.
Okay, so assuming those women exist, for those women who've decided not to proceed with an abortion, hasn't the waiting period facilitated informed consent?
So I'm sorry. So if a woman is at home and would like to get an abortion, and then she reads the material and waits 24 hours and decides not to get an abortion, no, I wouldn't say it's the 24-hour wait period that facilitated that.
All right. Well, I'll be more specific with my
Okay.
question. I'm speaking of a patient who thinks she wants an abortion.
Okay.
She goes to a clinic and
Yep.
the clinic says, well, we have to wait 24 hours, come back. And after 24 hours, she doesn't come back. She decides she doesn't want an abortion.
Oh,
I'm asking, did the 24-hour waiting period facilitate her informed consent decision?
No, I would say that the informed consent conversation that she was able to have with her clinician facilitated that. And by all means, if a patient would like more time to think about something after having that conversation with their physician, that would certainly be acceptable and could even facilitate that decision making. But it's not the state mandate of 24 hours that did that.
Are you saying then that those women should have had an abortion then, despite the fact that after considering it for 24 hours, they did not want it?
So if a patient doesn't want an abortion, we don't provide them with an abortion.
That wasn't my question. So we have a situation where a woman goes to an abortion clinic, wants the abortion, would have had the abortion that day if she could have. That was her intent. She's told to wait 24 hours. She decides after 24 hours, she doesn't want to go back. And she doesn't want the abortion. And you said that 24 hours didn't facilitate any informed consent.
No, what I'm saying is the patient had an informed consent conversation, which is part of your hypothetical, right? So if she presents to the clinic and she has a conversation about informed consent, and then she waits time and she decides to reconsider, it's not due to the state mandate of 24 hours. It's due to the doctor having a frank conversation about the relevant risk, benefits, and alternatives. And
That's an assumption I didn't put in the hypothetical.
so a patient presents to a clinic, gets sent away for 24 hours without interacting with the clinic?
The hypothetical, she wants it. She goes to the clinic. The patient, the clinic doesn't do the informed consent, right? Because they can't do it until 24 hours has passed, right? That's your understanding of the law, right?
My understanding of the law is that, yeah, these materials have to be provided 24 hours in advance.
Yes. So, and then the form that they sign for the informed consent happens right before the procedure, correct?
The informed consent form gets signed, at the procedure interaction.
Yeah. So you have a case where you have a patient who goes to the abortion clinic and they're told can't do it. Go home and wait 24 hours.
So go home and wait 24 hours and read the state mandated information.
I'm just saying, go home. Please don't add to the hypothetical. I want to make this.
That's how it works. Like
But
I can't do a hypothetical. That isn't what the law is.
I'm talking about the 24 hours.
Okay.
I'm asking the 24 hours. I'm talking about a situation where a patient wants an abortion, would have had the abortion, goes to the clinic for the abortion, because we've been told through testimony today that many women want the abortion that same day and they can't have it.
Mhm.
And they're sent home, right? There's been plenty of testimony about this testimony I disagree with, for the record, but the fact that this happens frequently.
Objection, I'm going to move to strike the other testimony.
I think that that's fair.
All right. So I'm talking about that situation where there's just 24 hours and they come back or they don't come back. And you said it's certainly possible that they don't come back. So in that situation where they don't come back, has that 24 hours helped them? And by informed consent, I'm talking about, right, you would agree that informed consent isn't finished until they consent, right?
So the clinical practice of informed consent is not finalized until the patient has consented,
Yeah.
correct?
So they leave, they wait 24 hours and they decide not to have the abortion. They decide not to go back.
Okay.
My question to you is, that woman, has that 24 hours facilitated her informed consent decision?
So I don't know why the woman chose not to come back. It might be that when she went home, she was then coerced by her partner to stay at home. It might be that she can't come back to the clinic because of transportation. So maybe it facilitated it and maybe it undermined it.
Okay, so in that situation, then, are you saying that she should have had the abortion despite the fact that after 24 hours, she did not have it? Like, she shouldn't have gone home, right? And had that time. Is that what you're saying?
Well, so generally the expectation is patients take the time necessary to think about a decision before they present to the clinic for a procedure. And certainly after a conversation with the physician, some patients either want more time to reconsider or decide not to go forward with the procedure. And that's all fine.
A patient can be under coercion without the person doing the coercion being present, correct?
Correct.
Right. And it's possible for a patient to be under coercion without showing any outward signs of coercion, correct?
Yes, that would be possible.
Yeah. And an abortion is a heavy decision, isn't it?
No, I wouldn't agree to that. I don't think it's heavy for all women.
Okay. So is it at all possible then for a provider to mistake signs of just a difficult decision with signs of coercion?
Well, so when you say mistake, the response to perceived signs of coercion would be to ask about potential coercion to ensure that the provider was not making a mistake.
You stated that we have a long history of not wanting women of color to reproduce, correct?
That is true.
Is that long history over with?
No, I would not say that that's over with.
And you provided an affidavit in this case that opined on the DHHS materials, right? Exhibit 4.
Correct.
However, you didn't read the materials before you wrote that opinion. Isn't that correct?
I didn't read what materials.
Exhibit 4. You were presented Exhibit 4 at your deposition and asked if you had an opinion on it, correct?
Yes, that's correct, that I was asked if I had an opinion on it. And I do apologize. I read a lot of material in preparation, so I don't exactly recall when I first read this.
Okay, so you don't recall stating to me that you probably have opinions on the material, but you hadn't read it?
I recall stating that, but in retrospect, after I reviewed it, it did seem very familiar after I reviewed it again. And I'm sorry, I just don't know exactly when I read it first.
No further questions, Your Honor.
Okay, thank you very much. Redirect?
A couple.
So good morning again.
Good morning.
Um,
Actually, Counselor, can I stop you for a moment?
Yes.
Is there any other defendant that has questions for this witness before we move to redirect? Okay, please continue. I'm sorry about that.
no problem. And Hillary Schneller for the plaintiffs. So you were just asked a hypothetical about a patient who comes into the clinic wanting an abortion, is turned away because of the 24-hour mandatory delay law, has not gotten any informed consent conversation from the clinician at that initial visit. And then for whatever reason, does not come back to access an abortion. Would you have concerns about causation and correlation in relation to the 24-hour delay law in that hypothetical?
Yeah, of course. And that's what I was sort of inartfully trying to say, is that just because a patient doesn't show up again after 24 hours it doesn't necessarily mean that 24 hours caused her to reconsider the decision and decide to stay home willingly to not have an abortion. Sure, I can imagine a circumstance where somebody might do that, but just because somebody doesn't show up for an abortion 24 hours later, I would actually hypothesize that it's more likely than not that the reason that they're not showing up, as we heard from Dr. Bagdasarian's testimony yesterday, is because it was snowing, is because it was raining, is because the bus wasn't running, because they met with coercion at home. Right. And so in my experience, when I was in law school, I worked with some minors who were trying to access abortion in Pennsylvania. And often it was transportation or their parents and being scared of coercion from their parents. And so if one of those teens hadn't shown up, I actually would have assumed it was probably parental coercion.
And informed consent generally, is it a process or conversation or something that occurs in the moment a patient signs an informed consent form?
Objection meeting.
Can you describe what informed consent is?
Sure. So informed consent is a process, not a document. And that is the way I've always taught it. Not only that, but there is a fair amount of research that demonstrates that if you want to, just because you say something out loud doesn't mean it results in retained knowledge for a patient. And so when you actually test the type of informed consent that results in the most knowledge retention for a patient, it's actually the conversation and not the form at all. But yes, legally, all hospitals require that patients sign the informed consent form. Yes.
No further questions.
Okay, thank you very much. Do you have any requests?
No, you're.
Okay, thank you, Professor, for
you.
coming this morning. You are excused. Now, we need to take a very short 10-minute recess just to have the technology set up for our next witness, who's going to be here by Zoom. No?
Your Honor, our understanding is the plans have changed in our next.
Oh,
Go ahead and do the document.
okay. Then,
Dr. Curley.
okay, then please call your next witness.
Intervening defendant calls Dr. Monique Blumenhurst.
And Your Honor, I'm just going to grab this binder.
Yes, please.
Just as a technical procedure, have plaintiffs rested.
Yeah, I'm sorry. So does that have plaintiffs rested their case? Is there anything else we need to do for plaintiff side?
Subject to any necessary rebuttal, Your Honor, at this time.
Okay, thank you.
Now intervening defendant
Okay.
calls Dr. Monique Blumenhurst. Swear or affirm most that the perjury that the testimony you're about to give is the truth, the whole truth.
Good morning, doctor. Can you please state your name for the record?
My name is Dr. Monique Bubenhorst.
Very good.
Can I adjust it?
Yes, of course. And do you mind spelling your last name?
Yes, Wubbenhorst.
Can you provide me with a brief educational history?
Yes, excuse me, my bit of a frog in my throat this morning. I graduated from Mount Holyoke College in 1981. I did my finished medical school at Brown University School of Medicine and had my MD with concurrent master's in public health from Harvard University. Then went on to do my residency at Yale New Haven Hospital before doing a postdoctoral fellowship at the University of North Carolina in Chapel.
And what was that that position at the University of North Carolina, Chapel Hill?
It was a research position in health services research. My specific focus was actually I had two foci. One was genetic epidemiology, and the other was to use large data sets to study health outcomes in women.
Did you provide any training when you were at Duke?
I'm sorry?
Did you provide any training while you were at Duke?
Yes, I was at Duke University on the faculty of the School of Medicine for 15 years, and I trained residents, medical students, and advanced practice clinicians.
What experience do you have conducting research?
As I mentioned, during and after my postdoctoral fellowship, I conducted research using large Medicaid data sets to look at pregnancy outcomes. I also used hospital administrative and clinical data to create a database to look at pregnancy outcomes, especially in minority women. I did genetic epidemiology research. I did research on proteomics, which is a study of protein expression in human placenta, as well as other epidemiologic research.
Do you have any peer-reviewed publications?
Yes,
About how many?
I think about 20.
Have you served as a peer reviewer?
Yes, for multiple journals and also for the,
And what does NIH stand for?
sorry, the National Institutes of Health.
What are some of the journals that you have been a reviewer for?
I've been a reviewer for the North Carolina Medical Journal, for PLOS, for British Journal of Obstetrics and Gynecology. I think there are a couple of others, but I don't have the CV.
And PLOS?
Pull the microphone just a little bit
Yes.
closer to you.
Is that better?
Yes.
Okay.
PLOS, what is that?
It's an acronym. I'm not sure why the journal calls themselves that, but it's a very highly rated journal that in the biomedical literature that looks at different types of biomedical research. And that's just their kind of quirky name, is PLOS. It's small p, capital L, small o, small s.
What certifications do you have?
I am board certified in obstetrics and gynecology. I'm a fellow of the American Heart Association, and I am certified by the National Board of Physicians and Surgeons.
And just to be clear, are those national certifications, all of those?
Yes.
How long have you been a medical doctor? Roughly.
34 years, I think. I haven't thought about this recently, but I think it's about 34 years.
And what year did you first become a medical doctor?
I began my residency in 1991.
Now, if you can go ahead and turn
And-
to, I believe, let me give you a copy. You can turn to plaintiff's 31. It's already been admitted. Crown exhibits. There you go. What is exhibit 31?
This is a copy of my most recent curriculum vitae.
Very good. And what are all of those letters after your name? What do those stand for?
MD is my medical degree. MPH is my master's in public health degree. FACOG is fellow of the American College of Obstetrics and Gynecology, and FAHA is a fellow of the American Heart Association.
And where are you currently licensed to practice?
In Indiana and North Carolina.
Can you tell me a little bit about where you have worked?
Over the course of my career, I think I've worked at, more than 25 hospitals and hospitals and clinics. The focus of my career has been care in disadvantaged and underserved women, specifically minority women. I spent a substantial amount of time on Native American reservations in the Southwest and in central United States. I've worked extensively internationally in multiple countries. Most recently, I'm licensed in, Liberia and Kenya. But I've also worked in South Sudan, the Philippines, India, Kazakhstan. I would have to look at my CV to see the other places.
And how about in Boston? What was your time in Boston?
So I went to Boston to serve to carry out an obligated period of service for to work in an underserved area. So I worked at an inner city OBGYN clinic. It was actually a health clinic, community health clinic in Roxbury, Massachusetts. And that was at the height of the crack epidemic. in the 1990s. And then a year later, I became the chief of OB at that clinic.
And so have you been an OBGYN throughout your career?
Yes, sir.
In addition to working at hospitals, what are some other roles that you have served in?
I have worked at the, because part of my practice was at the Durham VA Medical Center when I was on faculty at Duke. I also was involved with the senior leadership of the VA in designing women's health programs for the VA. I have also been involved in research. As noted, my affiliation with the American Heart Association was as chair of their Committee on Women and Special Populations, which was looking at cardiovascular disease in women and how to strategize improving care for women with cardiovascular disease.
And how about your current role? What is your current role?
I'm an OB hospitalist at St. Joseph's Regional Medical Center in Mishawaka, Indiana.
And what does that entail?
I work at on the labor floor, typically for 24 hours. During that 24 hours, I have responsibility for patients coming in through the emergency room who have no prenatal care, as well as transfers from other hospitals, high-risk patients, and also provide backup for the private practice physicians that do their deliveries at the hospital. I also have a teaching responsibility because I have an affiliation with the Indiana University School of Medicine as adjunct faculty. And so I teach residents and medical students.
What kind of procedures have you performed over the years?
I would say over the past more than 30 years, I have probably performed thousands of procedures, ranging from laparoscopic procedures to hysterectomy, vaginal hysterectomy, abdominal hysterectomy, tubal ligation, of course, cesarean delivery, cesarean hysterectomy, surgery on ovaries, pretty much the full range of gynecologic and obstetrical surgeries, as well as outpatient care and public health roles in the different communities I worked at.
Now, have you ever performed any procedures that are technically similar to an abortion?
Yes.
And just so that we don't have anyone talking past each other, can I get your definition of abortion versus termination of pregnancy?
Yes, I think it's an important distinction because abortion is intentional feticide. In other words, the goal of the procedure is the death of the fetus or the embryo. Any procedure that is done to save the life of the mother or to attempt to save the life of the fetus, I would classify as a termination of pregnancy. And the distinction is important because, as in law, in medicine, intent counts.
So what are the procedures that you have performed that are technically similar to abortion, but that you would consider a termination of pregnancy instead of an abortion?
So in situations where baby was demised, where there was a fetal demise, I have done suction curettage, sometimes suction sharp curettage in settings where there was no suction machine available. I have done second trimester dilation and evacuation, but technically not dilation and evacuation because the fetus was already demised. I've done induction of labor in the second trimester for demised fetus, and in the late second trimester and early third trimester, I have done labor induction where the fetus was still alive.
Now, you were asked to provide opinions in this case. What were those opinions based on?
My opinions were based on my clinical experience, on what I understood to be the law in Michigan, on my review of the literature, and on examining guidelines and other clinical information.
And do you have experience conducting this kind of research?
Yes. I've probably done tens of thousands of literature reviews in the course of my career.
And did you reach your opinions by relying on scientific methodologies that are widely used in your field?
Yes, I can describe, I'm sorry, based on scientific methodologies, you mean in terms of doing a literature review?
Mhm.
Yes, I used something called a snowball technique.
And did you reach your conclusions within a reasonable degree of medical certainty?
Yes,
Have you ever been qualified as an expert before, or presented as an expert before?
yes, sir.
Do you recall where and what courts?
The 7 cases that I am aware of were in Minnesota. I don't have them in chronological order. Is that okay? Minnesota, Kansas, Kentucky, Indiana, North Carolina, Colorado, and the Inter-American Court.
And where was the Inter-American Court located? What was that case about?
So
Or
the,
not about, just where was it?
so the case was based on a case in El Salvador, but in Latin America, they have an Inter-American Court, excuse me, which is somewhat similar to the European Court of Common Appeals, where the cases are heard there that reflect on the general, I'm not a lawyer, but general laws throughout South America and Central America. Is that clear?
I think so.
Okay.
Now, I have never had the experience of having an expert testify for free. Are you being compensated for your time?
Yes, sir.
And what is the rate of your compensation?
$800 an hour.
Your Honor, at this time, I would like to tender Dr. Monique Wubenhurst as an expert in the field of medicine, specifically obstetrics and gynecology and women's health, and as a medical researcher.
Qualified as an expert. So it's even quality, I'm not sure about the certain part, but I have to look at that on months.
Okay, sounds good.
Thank you. One more thing, are you a member of AAPLOG?
Yes, sir.
And what is that organization?
It's APLOG is the acronym, and it's the American Association of Pro-Life OBGYNs.
Now, you understand that here in Michigan, there's a constitutional right to reproductive freedom. Is that correct?
Yes.
And are you here to change that right?
No.
Are your opinions based on an assumption that that right exists here in Michigan?
Yes.
Do any of your personal beliefs color your opinions here?
No.
I'd like to talk briefly about informed consent. What is informed consent in the medical field?
Informed consent is a process whereby a patient will come to be seen in the office or the clinic, will present with a specific concern or clinical problem, which then entails a discussion about what her problem is, what might be the most appropriate therapies. There's then a process of screening, process of patient education, and after all that, then consent is signed and given by the patient for you to perform a procedure.
And why is informed consent important?
It's important for 2 reasons. The first reason is that there's a history of patients being subjected to clinical and research treatments that were abusive and coercive. The second reason is that to protect patients' autonomous decision-making, they need to have a process by which the physician and the patient can, through discussion and through a clinical relationship, arrive at a complete as possible understanding on the part of the patient of what the procedure entails, as well as its risk, benefits, and potential outcomes.
Have you ever consented patients? Is that the phrase that would be used?
Yes,
Have you ever consented patients?
many times.
Um, Are patient educational materials, standardized patient educational materials ever used in that informed consent process?
Yes, they are. And in fact, they're a real benefit in clinical situations in practicing outpatient medicine, especially where patients have limited literacy. It's extremely helpful to have standardized materials, and we often will seek those materials out and get excited when we have accurate patient education materials that have good graphics and clear, easy to understand text.
And in states like Michigan, is it helpful to provide those materials in other languages like Spanish or Arabic?
Oh, very much so.
What is the ethics of using these materials in the informed consent process?
I think the ethical considerations are that they help patients to get an adequate understanding of what the procedure actually entails. So for example, if I'm doing surgery for fibroids, which are very common, it's a common reason why women come to seek care because of bleeding and pain and abdominal enlargement. Drawing pictures of the fibroids so that they can see what they are, what their size is, what their position, or even better, having pictures in patient education materials enables them to see exactly what we're doing and why we may do a specific procedure. For example, this is a little bit of detail, but for example, if a woman's fibroids are very large, that may not be a procedure that you can do laparoscopically. You may need to use an incision. And so you'd want to show her, what does that incision look like? And that relates to issues like healing, postoperative pain, how long she can get back to work.
Now, if someone were to make the argument that there might be information in these patient educational materials that's not relevant to a particular patient, would that preclude a provider from using that material?
I don't think so at all. And I think that it gets to what I think is an important concept. I think that it's paternalistic for us to say this patient needs this information, this patient doesn't need this information. I think that if we want to provide the best and most optimal consent, we need to provide as much information as we can, consistent with the patient's ability to understand. And that also goes for patient education materials as well.
Has there been a history of abuse that has led to the creation of informed consent?
Yes. So the creation of the idea of informed consent came into view in particular after World War II, after the Nazi doctors were exposed and their activities were exposed at Nuremberg. That led to a consideration of the need for a variety of sort of ethical considerations. That was followed by the Belmont Report. And in addition, the other two significant examples were the Tuskegee syphilis research trials, where African-American men especially were infected with syphilis and then not treated. And the syphilis was allowed to take its natural history, which was painful and disabling, led to many of them having early death. They were not consented for this. They were not told of the risks and benefits. The second is the history, of course, of sterilization, in particular of women of color and men of color, as well as those who were mentally handicapped in the 19th and 20th centuries.
Well outside the scope of the testimony that she has come to this court to provide. She provided a declaration. This case does not touch on the history of consent. She was deposed on a number of issues. This was not one of them. And I don't believe that she's testified, she's qualified to provide a detailed history of consent.
Your Honor, there was no discovery request for an expert report. It was graciously provided by the defendants. It was not an actual written discovery request. In Michigan, there's no requirement that a party provide an expert report, unlike federal court. And Ms. Wubenhurst is testifying about informed consent. This whole case is about informed consent, and she has an understanding of the history of informed consent in the United States. She is a physician and she has to use informed consent all the time. And her basis for understanding the purpose of that, I think, is relevant to this case.
Your Honor, the parties worked very collaboratively, discovering our presentation for you today. We requested that expert reports of some kind presented to us so that we could list of testimony, and intervening defendants and plaintiffs working collaboratively in that regard. It really occurred to me that they might say to your Honor that we could submit a formal discovery request that we were somehow precluded from knowing the scope of the testimony that the experts were to provide. Now, Mr. Benson has qualified Dr. Rubenhorst as an obstetrician and gynecologist. We did not oppose that. That is certainly within the scope of practice for expertise. But there's no reason why a general obstetrician gynecologist would know the detailed history of informed consent. And so I maintain my objection.
So I think the parties have had a chance to do discovery and take the deposition and flesh out where the opinions of the witness are going to come from and the basis for them. I agree that Dr. Wubenhurst, as a practicing physician, does have some knowledge from her clinical experience of informed consent. So if you could just, in eliciting the testimony, provide the foundation for where she's getting this information from, I'm going to allow it.
Dr. Wubenhurst, can you provide a foundation for how you came to the knowledge for the answer that you just gave?
Yes, so as part of my work with the Center for Ethics and Culture at Notre Dame, I have done detailed examination, including using original documents from the 19th century and the 20th century on the history of eugenics, course of sterilization, and their effect on African-American populations, as well as those who were handicapped. I have spent many hours, many weeks researching this particular area of literature, and am extremely familiar with it in its entirety, I would say.
And we didn't cover every single line item on your CV.
Yes.
In your introduction, did we?
No, sir.
Your position at Notre Dame that is listed on your CV, is that correct?
Yes, sir.
Can you give me a little bit more of a description on what that is?
Yes, so I have been I'm a permanent fellow of the Center of Ethics and Culture at the center at the University of Notre Dame. I've been a fellow of the center since 2011. I participate in the activities of the center, including in developing policy, speaking at their annual meetings, and so on.
So we were talking about patient educational materials a few minutes ago. Do you recall that?
Yes, sir.
Do you think patient educational materials are a burden to patients?
No, I think that they are an essential component of the informed consent process.
And if these materials covered information that was not relevant to a particular patient, do you believe that they would then become a burden to the patient?
Again, I think that it's difficult to say what is or is not relevant. I think that we do want to avoid medical paternalism in trying to say that some information may or may not be relevant to that patient's understanding.
Why do you believe informed consent is, or I guess, yeah, why do you believe that informed consent is important in the abortion context?
I think that it's important in the abortion context because abortion is an irreversible decision. It has an impact on one of the most fundamental decisions that women can make, which is to have a child. And so I think that in addition to the
and
sorry,
if I can pour you, there's cups on the table there and water in the pitcher.
Great, thank you. Sorry, I'm sorry. Can you repeat the question?
Sure. Are there concerns about patients being consented in the abortion context?
Yes, thank you for reminding me. As I was just saying, because abortion is an irreversible decision, I think that it is extremely important to help ensure that women have their the information that they need to exercise their autonomous decision-making in the context, in particular, of Michigan's law ensuring reproductive freedom. In addition to that, there are risks associated with abortion, and those risks need to be clearly outlined to patients as well.
All right, now I would like to, and I'm sorry to make you do this, but if you can
No.
grab the other binder in front of you. And go ahead and turn to Exhibit A. And for plaintiffs, that'll be in the blue binder. Have you seen Exhibit A before?
Yes, sir.
And is this the updated version of the clinical policy guidelines for abortion care that you relied on in your report?
Yes, sir.
Can you tell me a little bit about the National Abortion Federation?
So the National Abortion Federation is a voluntary organization that seeks to promulgate standards of care and practice of abortion.
In your experience, are all abortion clinics members of the National Abortion Federation?
No,
Do all clinics follow these guidelines?
no.
Are there some clinics who might not? Well, go ahead and turn to the introduction. I think it's on, if you look at the bottom left-hand corner, there's a page 7 of 79. That's where the introduction starts. So in the second paragraph, it states that, like its predecessor or precursors, excuse me, the 2024 edition of the NAF's National or Clinical Policy Guidelines for Abortion Care serve to provide guidance for facilities to use in establishing their clinical policies. Is this your understanding of why this document was created?
Yes.
If we can go ahead and turn to page 16, I'd like to spend a few minutes there. Let's start with section 2. Do you see that at the top of the page?
Yes, sir.
It says patient education, informed consent, and counseling. Can you describe what those things are?
Based on this or on my understanding.
Based on your understanding.
So again, I think patient education means using discussion to educate the patient about the risks, benefits, advantages and disadvantages and outcomes of a particular procedure or intervention. Informed consent is the process, is the spectrum of activities where beginning with the patient encountering you, becoming your patient, being screened, receiving patient education material, having further discussion, and then signing the consent form.
Can you go ahead and read the policy statement aloud there?
Okay, policy statement, : a person must give voluntary informed consent prior to an abortion and express understanding. The goal of abortion education is to give people the knowledge they need to make an informed decision about whether to have an abortion and which type of procedure to choose.
So I'd like to talk about 3 different words that we see there: voluntary, understanding, and knowledge. Why are those important?
Because informed consent, let me back up. The word voluntary is important because informed consent cannot be said to have occurred if the patient is under coercion or duress. The second one was education, you said, sir?
Let's continue with understanding. I guess that kind of dovetails with education.
And understanding means cognitive ability to comprehend what the procedure is, what the risks and benefits, and then make an autonomous decision about whether to allow the physician to perform a procedure or help them with an intervention.
And in your experience, it states here, the goal of abortion education is to give people knowledge. What do physicians generally use to give people that kind of knowledge generally?
I think that in general, as a matter of practice, physicians will use patient education materials. And it's very interesting to me that patients want and need patient education materials. Very often they will come with something they've downloaded from the internet in hand and say, you know, is this the problem that I have? Is this the procedure that I need? And then what that shows me is that there is a need to provide that information, provide medically accurate information, and then also break that information down in a way that they can understand it. I think what was the third? Sorry.
Those were the three. I'd like to talk though a minute about, it states here that the goal of abortion education is to give people the knowledge they need to make an informed decision about whether to have an abortion and which type of procedure to choose. Why is that last clause there? Which type of procedure to choose? Why is that important?
Because there are different abortion procedures depending on the gestational age of the unborn child, as well as the amount of time that it takes to do a procedure and so on.
What are some differences between the procedures and medication abortion that an individual seeking an abortion may experience?
So in the first trimester, surgical abortion and medication abortion are the two options. They have different risks and benefits. With surgical abortion, the risks are procedural, having to do with the risk of perforation of the uterus, future infection, and then also actually future preterm birth. There is surgical abortion is associated with risk of future preterm birth. Preterm birth is a heartbreaking complication of pregnancy that happens and has been associated with surgical abortion. With medical abortion, there are not procedural risks, but the risks are also bleeding, infection, and retained fetal parts and placenta.
How would you respond to someone who says that it is not relevant to tell a person seeking a medication abortion about other procedures?
Well, I think that given that as many as 1 in 20 women, possibly more, will need a surgical procedure to complete the abortion, I think they need to understand what surgical abortion is. I think that also, excuse me, patients may or may not have their pregnancy accurately dated. Not long ago, I had a patient that came to the hospital, this is about 3 weeks ago, who had been having abdominal pain and bleeding and came in, and she was 22 weeks pregnant and didn't know that she was pregnant. I had another one not long after that who was 27 weeks pregnant and didn't know she was pregnant. And so if a patient were to come in, for example, thinking that she was in the first trimester, but in fact was in the second trimester, then she would need to know what the potential risks and benefits. But I think that as many as 3% of women who receive misoprostol or mifepristone for medication abortion may have ongoing pregnancy, and that if that she doesn't think that she's pregnant and continues into the second trimester.
I'd like you to go ahead and take a look at Exhibit 4 in the numbered exhibits. I think that binder may not have the numbers. It's the one
This one here.
to your right.
Okay.
This document's already been admitted. I'd like you to take just a minute to go through and look at the different abortion procedures that are listed in Exhibit 4, and go ahead and list them off as you come across them.
Page 3 of 45.
Let's go ahead and start with page 4. And that's Plaintiff's Exhibit, page number 4, or excuse me, 6 of 45 in the bottom right-hand corner. top of the page says medication abortion.
Yes.
So let's go ahead and look at the different types of abortion that are listed here in this document. The first one obviously is medication abortion.
Yes, sir.
If you can turn a couple pages. Next one is entitled suction curettage.
Yes.
The next one, a couple pages later on page 10, is second trimester labor induction abortions.
Yes.
And then on page 13, it's dilation and evacuation. Is that
Yes.
correct? Are there, does this list include the available abortions that a woman could seek?
You mean the available abortion methods?
Yes.
Yes.
I'd like to look at the risks that are listed. Let's go back to page 6.
Of which?
Actually, let's start with medication abortion. It's page 6 of 45. Let me know when you're there.
I'm there.
So the first 3 paragraphs under medication abortion describe the medication abortion. Can you go ahead and read those?
Sure. It says medication abortion in bold. Then various drug regimens and medications may be used to end an early pregnancy. A new paragraph. Medications used to end an early pregnancy may work to block a hormone that is needed for the pregnancy to continue and or work by causing contractions of the uterus to cause the pregnancy to end. Third paragraph, you should speak with your provider for more detailed information about the specific regimen that is right for you. Your provider can also explain any requirements related to in-person visits, physical examinations, and the correct use of medication.
Is that information an accurate medical reflection of the abortion procedure?
Yes.
Or excuse me, the medication portion there. Is this the type of information that you would expect to see in standardized patient education materials?
Yes, to the extent that I have not consented a patient for abortion, but this is similar. The wording is similar to what I have seen.
And do you see anything in that description that is intended to be biased or to influence the outcome of a decision?
No, I believe this is neutral.
Let's go ahead and look at the risks associated with medication abortion. Can you go ahead and read those?
Yes. Bold, risks associated with medication abortion. There are some risks and problems that can occur with medication abortion. Talk with your provider about potential risks. Following a medication abortion, vaginal bleeding and uterine cramping will occur in almost all patients. In some cases, bleeding can be very heavy. This can feel like a heavy, crampy period. Expect bleeding or spotting to occur for an average of 9 to 16 days, although it may continue for 30 days or more. In some cases, too much bleeding may require blood transfusions, treatment with medication, and or surgery. Other risks related to medication abortion may include infection, incomplete abortion, or the need for emergency medical treatment. Common side effects include nausea, vomiting, and diarrhea. As with any medical procedure, death is a risk. Death related to abortion occurs in less than 1 of every 100,000 abortions. Shall I continue, sir?
Sure. Well, let's take a pause right there. Is this medically accurate?
Yes.
Now, I could understand that a patient may have conditions that would mean that their risks are higher in particular areas. But would there be a case where the risks might be lower than what's listed here?
I don't think so. I think this is an adequate description of what the risks are of medication abortion. It's possible that a patient could have lower risks, but again, we want to provide the best possible information for her to make an autonomous decision. I think that as far as the higher medical risks that you were mentioning, that's the purpose of screening. Screening would hopefully detect a woman who had a history of a bleeding disorder or some other problem.
And to me, this kind of, I watch football on Saturdays and I see lots of drug ads. To me, this sounds similar to the risks that are listed in those drug ads. Is there kind of a comparison between those that you could make?
Objection.
I'm not sure about drug.
Allow it.
Yeah, I would say that this is similar to what you would see, but also similar to see in a, you're talking about a pharmaceutical ad that you see
Yeah.
for different medications. I would say it's similar to that, but it's also similar to, the language is very similar to, standardized informed consents forms that we use. Is the same language as with any medical procedure. Death is a risk. I've seen this countless times in standardized medical consent forms.
And this description of the risks, if you can go and look at the document that's open next to you, the National Abortion Federation document, it lists some risks there. These are not, these two lists of risks are not inconsistent, are they?
No.
Objection lead.
I would say they're very similar.
Wait, hold on one second.
Oh, I'm sorry.
Um, Can you rephrase that question, please?
Sure.
Okay, thank you.
Can you look at those two documents in front of you? And how would you, in your expert opinion, compare the lists of risks? Are they similar?
They're similar, and I think that the list of risks in the DHHS material is more detailed.
I'd like to go on to the next paragraph. It's rare, but some individuals, it starts there. Can you read that?
Yes, it is rare, but some individuals may have feelings of sadness, guilt, anger, trouble sleeping, or doing daily activities after an abortion. These symptoms can also occur after the birth of a baby or after a miscarriage. Call your provider, community mental health authority, local health department, or local human services office for help if you have any of these symptoms that are strong or lasting.
And in your experience, have you provided care for women who have had abortion?
Yes.
Have you witnessed these feelings in those women?
Yes, I have, in the course of my career, probably, as I noted, cared for thousands of women, many of whom had had an abortion. I would say that in my clinical experience, every woman that I cared for, none of them said that their abortion was a good experience. Some of them said they had to do it.
Sustained.
Experts can rely on hearsay, informing
They
their
can't rely
opinion.
on hearsay.
I think she's giving testimony about, I think it's outside the scope of her expertise. She's not giving a medical opinion right now. She's testifying about what it's anecdotal evidence about patients.
Okay. In your experience, generally as an OBGYN, treating women who have experienced abortion, I think there's been testimony here from every OBGYN that some of their patients have experienced these feelings. Have you ever encountered patients as an OBGYN who have experienced these feelings?
Objection, I believe that misstates the.
Okay, I'll withdraw that portion of the question.
Please speak to your clinical experience, doctor.
Yes, my clinical experience is, as I was saying, is that my patients have told me that you're talking about clinical experience?
Yes,
I don't
Doctor,
understand.
can you talk about it in a way that doesn't rely on restating what patients have told you?
Okay, I'm just trying to do the right thing here. So patients in my practice have reported feelings of sadness. Is that
Yeah, you can continue.
okay? So patients in my practice have, like other OBGYNs, have reported these feelings that they're describing here of sadness, guilt, anger, trouble sleeping, or doing daily activities after an abortion.
So in your experience, is this paragraph medically accurate?
Yes.
Now, is this paragraph communicating some kind of mental health diagnosis?
No.
And are you conflating here feelings with the mental health diagnosis?
No. I think that what they're saying here is that women undergoing abortion may experience these feelings And if these feelings are strong or long lasting, that they could seek medical attention. And in that situation, a clinician would then make a diagnosis of an adverse mental health outcome, for example, depression. Does that make sense?
Thank you.
Okay.
I'd like to direct your attention to standard 2.1 in the document next to you. It's in Exhibit A. Go ahead and read standard 2.1, if you would.
Under informed consent,
Yes.
under informed consent, it says standard 2.1 in bold. Then goes on to say the practitioner must ensure that accurate information is provided about the abortion process and its alternatives and the potential risks and benefits. The patient must have the opportunity to have any questions answered to their satisfaction prior to intervention. And then it goes on to option 2.101.
Let's just stop there for a moment.
Sure.
Does this medication abortion description, what you've read here, is it accurate information according to your expertise?
Yes.
Does it describe the abortion process, the medication abortion process?
Yes.
Does it adequately discuss risks and benefits?
Yes.
And what would you, there's the word alternatives there. Do you see that kind of in the middle of the standard 2.1?
Yes.
How would you interpret alternatives?
I would interpret alternatives to mean potential other choices that a woman could make. In addition to abortion, those would include carrying to term and parenting her child, or carrying to term and putting her child for adoption.
I would like you to, in the binder on your right, turn to Exhibit K1, which has already been admitted.
You mean on my left?
I apologize, you're right, or your left.
Okay.
If you can go ahead and turn to the second page there.
Yes.
Do you see the language options?
Yes.
Can you read that?
Yes, it says in bold options, colon. I understand. Abortion, adoption, parenting. I understand. I understand there are two ways: abortion, medication abortion, and an abortion procedure. I understand that. After the study of all of these options, I make a decision.
And do you understand from this that those options are alternatives?
Yes.
If you can go ahead and turn to Exhibit F. And this document also has previously been admitted. This is from Northland's website. Can you read that first paragraph?
Yes, it says, when you come into Northland, well, it says, I'm sorry, it starts adoptions in Michigan in bold, large font. Underneath that, it says about adoption in bold. Then says, when you come to Northland with an unplanned pregnancy and are unsure of what to do, comma, we will review all of your options, including abortion, comma, parenting, and adoption, period. We have always believed that adoption may be the best choice for some pregnant people, semicolon, but it should be just that, ellipsis, your choice.
Is that statement consistent with the NAF guidelines?
Yes.
Now, if you would go back to Exhibit 4.
I'm there.
And actually, we're going to go to Exhibit 1, which is the law. Just one moment, page 3. Let me know when you're there. Now, here it says, if you can look at, you see the 11, and then we've got a sub B under that, and further down, there's little Roman numeral V, VI, and VII. You don't have to read that out loud, but go ahead and read those.
So you're asking me to read V, VI, and VII, is that correct?
That's correct, right before the little C. You can stop there.
Yes, I read that
And so
text.
the last one says, the different services that are available in the counseling to provide those for someone who's pregnant. Informing individuals of the resources that they're able to obtain, is that consistent with the NAF standard regarding alternatives?
Yes, as far as I can tell, yes.
Now, the last portion of the NAF guidelines that we were talking about says the patient must have the opportunity to have any questions answered to their satisfaction prior to intervention. Do you see that? I apologize. We're in Exhibit A. Page 16 of 79. So that last statement, have an opportunity to have any questions answered to their satisfaction prior to intervention. I'm going to ask you to look at specifically the law. It's going to be in that document, the other binder that's open in front of you, page 2. Go ahead and look at 6, and the sub is B. Go ahead and read that. You can read that out loud. Go ahead and read the first subsection. And the Roman numeral little II. I'm going to ask you to turn to page 4 in that same exhibit. And do you see, it's about a quarter of the way down the page, a large G, capital G.
Yeah.
What does that state? Is your opinion, what is your opinion regarding the consistency of these provisions with the NAF standards? Go ahead and turn to Exhibit 4. Now, we were already looking at medication abortions. I don't know that we need to spend as much time with each of these procedures. Can you just look at the risks and complications associated with pregnancy and delivery? You don't need to read those out loud, but go ahead and look at that paragraph. Page 6 of 45. Let me know when you're done. In your expert opinion, is this medically accurate information? Is it information that's relevant to pregnancy? All right. Have you had an opportunity to review all of these different procedures that are described in the DHHS materials? What is your opinion on the accuracy of these materials from a medical standpoint? Now, I'd like to direct your attention to Exhibit J2. And this has previously been admitted. Go ahead and turn to page 4. There's a subsection entitled, "What is mifeprex?" The second paragraph there, it starts the pregnancy. Can you go ahead and read that? So if Northland, and we don't need to know exact numbers, but if, let's just say, let's use a round number, if there were 1,000 medication abortions a year, with that hypothetical, per year, how many patients would need an additional procedure in addition to the medication abortion? And that's a significant number of women who may need a procedure, don't you? Wouldn't you agree? I can rephrase the question. Would you ascribe any significance in a number of that amount?
Can you make sure that the microphone is close to you and speak up a little bit, but thank you. Does she need to repeat it? We're good, thank you.
Would it be in the interest of informed consent to consent a patient just to the medication abortion without describing what might also need to be a procedural abortion conducted later on? In your experience, do you believe that it is a burden on patients to provide them information when they're seeking an abortion, to provide them information about birth and or adoption?
Mr. Asmussen, I'm sorry to interrupt you, doctor, but can you please check and see if her mic is working?
Absolutely, sure.
So I'm having a hard time. Yeah, so I'm having a hard time understanding or hearing you. Let's take a short 2-3 minute recess
Very good.
to get this taken care of. Thank you.
Thank
very
you, Your
much. Yeah.
Yes, we are definitely calling Dr. Curlin. We just figured he's
Back. Please be seated. Thank you very much. Dr. Rubenhorst, you're still under oath. Mr. Asmussen, you may continue.
Thank you, Your Honor. Madam Court Reporter, can you please read back the last question?
Yes, I would say I'm sorry. What I would say is that as a physician, understanding the term burden in its usual sense, as an impediment, I would say, no, I do not agree.
Um,
It's a lot better now.
Very good. So it's not, is it a burden on the patients to inform them then about alternatives, those alternatives being adoption and birth?
No, and in particular because it is discussed in, for example, the National Abortion Federation guidelines that alternatives should be presented to the patient.
And what are the rates of, can you give me some examples of rates of fetal abnormalities? We've heard a lot about those at trial.
Yes, so two fetal abnormalities that you could think about as being associated with death soon after birth would be anencephaly. The rate of anencephaly in the United States is 1 out of every 5,246 pregnancies. Rates of renal agenesis, which is another abnormality, which consists of a baby not having any kidneys develop. And because the kidneys don't develop, the kidneys are the main source of amniotic fluid. And amniotic fluid is fetal urine. As that is produced, it provides a zero gravity environment for the lungs to, I'm just trying to explain what it is. Provides a zero gravity environment for the lungs to develop and expand. When there is no fluid, the lungs never expand and develop, and that's called pulmonary hypoplasia. So without functioning lungs, those children typically die soon after birth, where they don't have any kidneys. Sometimes they have one kidney, but sometimes they have not. And the rates of renal agenesis as a congenital anomaly in the United States are 1 in 3,000 to 1 in 4,000 births.
And what is the state of prenatal surgery in the United States right now regarding some of those abnormalities?
It's very exciting because that fetal surgery began to be a major force in medicine and perinatal medicine, I would say starting about 20 years ago. But actually, you have one of the leading, if I'm recalling correctly, one of the leading centers is here at Henry Ford Hospital. And if I'm recalling correctly, that program was started by a doctor who's a fellow when I was a resident at Yale. And so fetal surgery has revolutionized the treatment of fetal anomalies that were previously thought to be uniformly fatal, uniformly lethal. Some good examples are spina bifida, where they actually open the uterus, take the baby out, repair the defect, put it back in. There are some abnormalities where the baby doesn't have a connection doesn't have sort of normal connections in the lungs, so they can insert a clip to allow the lungs to expand normally. Even in this one disease that I was talking, abnormality that I was talking about, renal agenesis, there's a trial ongoing right now called the RAFT trial, where what they're doing is that since the baby can't produce urine on their own, what they're doing is that they are instilling fluid into the amniotic cavity so that the baby's lungs can expand. And that's actually a clinical trial that's underway right now.
Now, the constitutional amendment that's at issue here in this case says that every individual has a fundamental right to reproductive freedom, which entails the right to make and effectuate decisions about all matters relating to pregnancy, including but not limited to prenatal care, childbirth, postpartum care, contraception, sterilization, abortion care, miscarriage management, and infertility care. Do you believe that providing patients with information about childbirth and adoption is inconsistent with the right to reproductive freedom from your perspective as a medical profession? I think I narrowly tailored that to limit it.
Going to allow her to answer the question based on her expertise as an OB-GYN.
Yes, I think that true reproductive freedom means knowing what all your options are and being able to exercise those options. But in order to exercise those options, you need to have an understanding of what, you need to have knowledge. You need to have an understanding of what information is there to enable you to make the right decision for yourself.
So what are some reasons why a patient may choose, well, I guess, let me go back just to kind of set up this question. Go back to page 16 of Exhibit A, if you would, and that'll be on the binder next to you, yes. The policy statement there states that the goal of abortion education is to give people the knowledge they need to make informed decisions about whether to have an abortion and which type of procedure to choose. In your medical experience and expertise, why might someone choose a procedural abortion over a medication abortion?
Yes, I think it's a good question because many women feel that medication abortion is not surgery, it's not surgical. And so by taking the pills, the mifepristone and misoprostol pills, they may feel that that's less invasive. With the surgical abortion, they may feel that they want the speed of having surgical abortion instead.
Are there different risks associated with the two procedures?
Yes, as I was saying, the risk of needing a follow-up procedure after, as we saw earlier from the Danco package literature, they listed a risk of 2.7 out of 100. But there are studies that show that it can be as high as 1 out of 20. Patients will need a follow-up procedure. The risk of ongoing pregnancy after surgical abortion is lower. And so that is a risk that is lower, surgical abortion. And for the most part, the risk of retained placenta and fetal parts is lower after surgical abortion as well.
How could the pain compare between the two levels of pain?
So one of the interesting papers that came out recently was a paper by Hannah McCulloch looking at specifically at this question in Wales with the mifepristone and misoprostol regimen. And what they found was that women felt that they had not, that not only was the experience in many cases much more painful than they thought, but that they didn't receive adequate counseling. With surgical abortion, again, having done analogous procedures, typically after you prep the patient and you've applied antiseptic to the cervix, you'll grasp the cervix and then you'll inject local anesthetic around the cervix before you begin to dilate. And so that you have pain medication on board to try to prevent that discomfort, and then you give them pain medication. Is that
Can there be pain associated with a medication abortion as well?
right? And that's what the Hannah McCulloch and her colleagues found was that I think a third of women described the pain as excruciating. One woman who had had and this is in the paper, one woman who had had children said that it was equivalent to labor contractions.
It's based on a
I'm
study.
quoting, I'm sorry.
Your Honor, for Michigan Rule of Evidence 707, should not rely on hearsay and don't treat this on the record.
Your Honor, an expert witness can rely on hearsay in the formulation of their opinions. And specifically, the site for that is Enrique Castro, 344 Mich. App 590. It is a standard fundamental precept of law that experts can rely on hearsay data. The plaintiff's experts all relied on studies. They talked about those studies, and all studies rely on hearsay, which is reporting things within those studies.
Can you restate the question for me so that I have a context of what I'm
Sure.
considering?
I can.
And not for you, doctor, just for myself.
Could the court reporter read back the question? I apologize.
So I think that if I'm understanding the objection correctly, is that she's testifying about pain associated with medication abortion, but she's not testifying about based on her clinical experience because the doctor has testified that she hasn't treated people for medication abortion or done that. So I think that the distinction is that she's not using this study as a basis to inform her clinical experience or her own expert opinions. She's using it to, for lack of a better word, read a statement into the record.
All right. My response to that would be that she is a medical researcher, and part of doing medical research is being familiar with the literature in a particular field, and that literature informs experts to be able to arrive at an opinion, and they're permitted to rely on that literature. Plaintiffs have placed all of their reliance on literature, and so I'm not exactly sure why defendants' doctor relying on literature
Then you're going
is
to have to
inconsistent.
narrow it for me when you say that she's a medical researcher. At least from my understanding of her prior testimony was that she uses the scientific method and like she reads medical literature to
And she's
keep
published.
Yes, and she's published, but she says she's published in 20 journal articles. So I'm going to need you to narrow and specify what is she published in, what is she
Okay.
what does she have the expertise to opine on? And then based on that, then we can either allow her to, is this stuff that she relied on informing her medical opinion? Is it within the scope of her expertise? Is it within the scope of studies that she has published, research that she has done? Is it within the scope of her expertise as a clinician? If it falls within that purview, then absolutely please have her rely on it. If it's
We'll go ahead
outside of
and
it, then
lay a foundation.
And
Okay.
if I may, Your Honor, the distinction, another key distinction here is that none of plaintiff's experts read statements from the medical literature, whether it be from memory or from the actual studies verbatim into the record. Certainly they talked about their involvement in studies like the turn rate study, but what happened just now in that testimony was very different.
I don't know that she was reading anything.
She was reading from memory. This is exactly what happened in the study, which none of plaintiff's experts did.
So at least from my perspective in evaluating the doctor's testimony, I would like her to rely on and talk about things that she has relied on to form her opinion.
Very
And
good.
I will, in order to, just the competency of her testimony, I want it to be based on either research that she has done or within the scope of her clinical experience. And when I say research that she has done, it needs to be beyond just having read the study and absorbed it. It has to also be tied into work that she has done in publishing.
Okay.
Thank you.
So Dr. Wubenhurst, I would like to talk briefly about your clinical experience. Have you interacted with patients who have experienced abortions?
Yes.
Is it your opinion that there is pain that can be associated with medication abortions?
Objection needed.
I'll reformulate the question. Do you have an opinion about whether or not there is pain associated with medical abortions?
Yes.
Objection. It's testified that she's treated patients with abortion, but not necessarily patient abortion.
I'm not done laying the foundation, Your Honor.
I'm gonna allow him to lay the foundation and have her testify to this.
What is the basis for your arriving at those conclusions?
I have cared for patients who have undergone surgical abortion and medication abortion.
Have you done any research in this particular field?
In the area of pain with abortion? No.
Um, Based on your clinical experience, has there, based on your clinical experience, what is your understanding of the pain associated with medication abortions?
So I think that a comparison can be made between the pain associated with medication abortion and pain associated with miscarriage. Because essentially what medication abortion does is to cause the death of the embryo through the action of mifepristone and then contractions of the uterus with misoprostol. And we use misoprostol to treat incomplete miscarriages, miscarriages where the baby hasn't passed. And so it's an analogous situation in terms of caring for patients who have had similar clinical course, as it were, except that in one case it was abortion, in another case it was miscarriage. And there can be a substantial amount of pain associated with passage of the fetus.
And in your clinical experience, have you witnessed the pain associated with miscarriage?
Yes.
And how would you describe that?
In some women, it's excruciating. They need, most women need something like ibuprofen, but some will need narcotics. And this is especially true at higher gestational ages, above 8 weeks, up to 10 weeks.
Do you understand how medication abortion works?
Yes.
Now, we've talked about not necessarily emotional, or excuse me, we've talked about generally emotional health as it relates to abortion. Do you recall those conversations?
Yes.
And this isn't a DSM diagnosis that we're describing, that's being described here in Exhibit 4 of the DHHS materials, is it?
No, it's asking when they're talking about sadness and so on and so forth, it's patient's subjective responses.
And there have been a number of different literature reviews. What are literature reviews?
Literature reviews are when, having done them, when you examine the literature to try to understand a particular, or I'm sorry, there's a better way to phrase it, to try to answer a particular question.
And can you describe the process of a literature review?
So with a literature review, there are different ways to do it. I can speak to my own personal process for doing these. You look at databases, research and clinical databases. The most common ones are, excuse me, Medline, PubMed, Embase, and CINAHL, CINAHL, all caps, which captures the nursing literature as well. And you pull topics on, and then Google Scholar, you pull papers that are according to specific search terms that you use. You look at those papers, then I think I mentioned the snowball technique earlier. You look at the papers that those authors cite and then look at those papers as well. Sorry.
Now, there was some discussion about a turnaway study. Have you reviewed the turnaway study?
Objection, Your Honor, I don't think there was discussion.
There was a whole lot of discussion a couple of days ago when Professor Biggs was testifying about the turnaway study. There were attacks that were made on Dr. Rubenhurst's research, and I would like her to comment on those attacks that were made a couple of days ago. Are you aware of the turnaway study?
Yes.
Can you generally describe the turnaway study?
Yes, so the Turnaway study was a study which enrolled women in abortion clinics and who came to a clinic for an abortion. It's called Turnaway because some women who wanted to have an abortion could not have that abortion based on the fact that their pregnancy was too advanced. And in a particular state that they lived in, they couldn't have an abortion past a certain gestation age. And so it followed those women for 5 years and looked at a variety of different outcomes.
And do you have any critiques of the Turnaway study as a medical researcher?
Yeah, I think there are different critiques. One of the most important ones is that only 19% of the patients that were enrolled finished the study. And so well, first of all, only about 40% of patients completed the form, then only about 19% completed the study. So that even though they were able to follow many patients up to 5 years, it's hard to generalize when you have such a small number of patients remaining in the study till the end. Another concern is that there were different questions about data and the conclusions that were reached. And so in this type of research where you create a database, it's common practice to put your data into a data repository. For one of my studies, that's what we did. It's called Dryad. Dryad is one of several. And what that enables people to do is to reanalyze your data to see if they come to similar conclusions. And that hasn't happened with the Turnaway study. And so because it's so frequently cited, it would be helpful to be able to look at that data.
And this 40% participation initially, how would that impact the study?
Well, one of the questions that could be asked is that women who felt had more negative response to their abortion might be less inclined to continue in the study. And so what that would mean is that the characteristics of women who continued in the study would be different from the characteristics of all women who had undergone abortions. And
in research or scientific terms, what would we refer to this as, this selection process?
It could be called selection bias. It could be attrition bias. There are different names for it.
There was also discussion of an APA literature review and a National Academy of Sciences literature review. Are you aware of those literature reviews? What are your opinions of those literature reviews as it relates to the emotional, I guess, for lack of a better word, consequences of an abortion?
So I think that the National Academy study had some very significant flaws. One of the most important is that there is a fairly expansive literature on this question. And I would characterize this as a contested literature. There are studies showing that abortion has negative emotional and mental health outcomes. There are studies showing that it has no effect. There are studies showing that they're positive. And I think that it's important to acknowledge that it is a conflicted literature, and there are quite a few studies that have been done in this area. When you look at the methodology that they used, they restricted their final, in their meta-analysis, they restricted their final number of studies, something like 17 or 19 studies out of many, many other studies. And all of those studies reflected a benefit or no of abortion.
And are you taking any, in this contested area, are you taking a position on whether or not there are mental health diagnoses that directly result from abortion?
No.
And then if you would, well, so I guess with the Turnaway study, in your understanding, has there ever been a disclosure of the actual data that was relied on?
Not that I'm aware of. I haven't looked within, say, the past year to 2 years, but my understanding is that the data was not put into a research study.
And why would you put data into a research depository?
Because as with the paper that I previously did on abortion, abortion in the Federated States of Mexico, it enables researchers, number one, it's a benefit because they can go in and reanalyze your data. They may be able to pull out some additional facts or conclusions. And it also helps to show that this is how we did this analysis. You can look at our analysis. You can judge for yourself whether our analysis and the conclusions based on that analysis were accurate.
Can you go ahead and turn to Exhibit 1, page 3?
And there.
All right, and specifically subsection 11, then we go to B, and it's little Roman numeral 3. It's roughly halfway down the page. Do you see that?
Yes.
It says, state that the result of an abortion, that as a result of an abortion, some individuals may experience depression, feelings of guilt, sleep disturbance, loss of interest in work or sex, or anger. Do you interpret this as a medical professional as a description of some kind of medical health diagnosis? As a medical health, I'll rephrase the question. As a medical professional, how would you describe the things that are being described here? Is it a mental health diagnosis or something else?
I think it's a description of the emotional reactions that a woman might have following an abortion. And it also leads to what I think is a helpful statement that if these symptoms occur and are intense or persistent, that she might be professional.
Let's go ahead and look at Exhibit 4, and we're going to get past all of the descriptions of abortions and abortion procedures and go to the fetal development chart. Have you had an opportunity to review the fetal development chart?
Yes.
What is your opinion of its medical accuracy?
I think that it is medically accurate and it puts medical realities into terms that patients can understand.
Have you ever used the fetal development chart in your practice of medicine?
Yes, many times.
And what are some of the purposes of using the fetal development chart as an OBGYN?
I think that in prenatal care, women are very curious about what the appearance of their baby, the size of their baby at different gestational ages. I think that for women who are having pregnancy complications, for example, miscarriage, it's helpful to show them the size and development, in particular because that has a bearing on the amount of pain that they might experience if they've had a fetal demise, but the baby hasn't passed.
In the abortion context, how could this material be relevant to a patient seeking abortion?
I think there are a few ways that it could be relevant. One is that, as I've said, gestational age associates with the amount of pain, in my experience, that women experience passing yes, and this is especially true in the second trimester. So seeing the size, I think, is helpful. And getting back to the question of reproductive freedom and autonomous decision-making, part of understanding the spectrum of fetal development is helpful in assisting a woman to make her choice as to whether she wants to undergo abortion, carry her child to term, or carry her child to term and adopt out.
And again, the constitutional right is a right to make and effectuate decisions regarding pregnancy. You understand that to be the case, is that correct?
Yes,
Do you think providing a fetal development chart is consistent with understanding pregnancy?
yes,
Do you believe that it is important to understand pregnancy in making decisions related to pregnancy?
yes.
Why?
Because if, for example, a woman comes in for a second trimester abortion, she should understand what that abortion entails, whether she's having induction abortion or a procedural abortion. If she is if she's planning on carrying to term, to either try to parent or to adopt out her baby, it's helpful for her to understand what pregnancy and fetal development look like.
How would you respond to the charge that this chart may not be accurate for a patient who has fetal anomalies?
What I would say is that there are entire volumes that are this thick. The one I'm most familiar with is called Smith's Recognizable Patterns of Human Malformation. And it would be impossible to have all of these anomalies in this picture. In addition, when anomalies are identified, most physicians will give a detailed prognosis as well as what the anomaly entails, either anatomically or physiologically.
And when you said this thick, just for the record, about how thick was that?
The book,
Yes.
it's literally, it's thousands of pages.
Is that like 3 or 4 inches thick?
Oh yeah, at least 4, even 5 inches thick. It's a huge volume.
So overall, how would you describe the DHHS materials here? You've reviewed all of Exhibit 4, is that correct?
Yes.
How would you describe them?
I would say that they're medically accurate. They are written at a level that patients can comprehend, bringing medical information to a level that a layperson could understand, and that they're neutral.
Do you believe, or I guess, let me rephrase that question. In your medical expertise, do these materials burden or support a patient's right for reproductive freedom?
So looking at it, the word burden, because I know that has a legal meaning, but looking at it, that word, the way a physician would as an impediment, I think they support reproductive freedom. Again, if we want women to engage in autonomous decision-making, which, as stated in National Abortion Federation literature, includes the option to undergo abortion, parent, or give their child up for adoption. I think this supports that decision-making because she can understand exactly what the stages of fetal development are.
Now, in Exhibit 4 specifically, can you look at page 5? Page 5 of 45.
Yes.
This is the pre-screening summary for coercion.
Oh, okay. I'm sorry. I'm in the wrong. I'm sorry. You said 5 of 45?
It's exhibit number 4. And
Okay, I'm in
page,
the wrong place. Sorry. Give me a
Sure.
minute first.
page 5 of 45. Have you
Yes.
had an opportunity to review this information?
Yes.
It says here, what is coercion to have an abortion? It states, under Michigan law, it is illegal to coerce a woman to have an abortion. Actions like assault, making threats to hurt, embarrass, or cause psychological or financial problems to any person, as well as harassing, restraining, or taking important legal documents, are all forms of coercion. These are crimes that can lead to imprisonment and/or fines. Michigan law adds fines when these illegal behaviors are used to force women to have an abortion. You have had experience serving underserved communities throughout your career, is that correct?
Yes.
How would you see this pre-screening information as affecting underserved communities?
I think this is very positive. My direct experience in working both in the inner city, in rurally impoverished areas like Appalachia, Native American reservations, as well as internationally, coercion is very common. And it's not only common, it's very destructive. I think that this is really extremely important. And I really think this is great because there's evidence that many women are coerced into abortion, that we know that women in trafficking situations are coerced into abortion. And you can't give informed consent for any intervention if it's coerced. That's the anti-definition of informed consent is coercion. And so I think that this is a huge step towards protecting patients, protecting women from coercion. For example, there is a study which I cited in my expert report by Glander, which showed that 40% of patients presenting for abortion are victims of domestic violence, which is a shocking statistic. And so screening for coercion, I think, is integral to the concept of reproductive freedom and autonomous decision-making.
How would you respond to a charge that this language here might intimidate someone because of prior experience with law enforcement?
I think that our focus here is on the woman. It's not on some perception of police brutality or law enforcement or anything. Women, when approached and asked directly about this, will say, this is the first time anyone has ever asked me if I've been abused. And I think the imperative of
I don't think that there was anyone in particular that she was quoting. I think this is
He's
her
not quoting, but can you limit it to your clinical experience, please?
that's what I'm speaking of. I'm speaking of my own patients that I've cared for who've been in, is that okay? Yeah, okay. I'm speaking of my own patients that have been in coercion, domestic abuse, prostitution, that after talking to them, I would ask them and they would say, you're the first person who ever asked me about
I'm certain they don't want this information on the record, Your Honor, but this is
think-
information, this is
well-
information that is made in a diagnosis. So it's an exception to hearsay. This is from her own clinical experience. And so it's an exception to hearsay in that it's made for medical diagnoses. These are meetings that she has had with patients. She's speaking about her particular experience. She's giving hypothetical examples of experiences that she's had over the years. She is permitted to rely on those experiences to form the basis of her opinion. I understand why they don't want to talk about this.
Let's just keep it to the legal issues before us. I agree with you that she is allowed to talk about her clinical experiences. My concern with this testimony is that I think the doctor previously testified that she hasn't treated or consented anyone for abortion. So I would like her testimony to be narrowed and applicable to the issue that is before us, which is coercion in the context of abortion and abortion screening.
And okay.
And if I may, Your Honor, while she can testify to her observations as an OBGYN, it is not an exception to hearsay that any expert can testify to what other people told them. That is not what the hearsay exception to expert testimony applies to. It applies to things that form the basis of their opinion, but you cannot have an expert come in and say, this person told me X, Y, and Z. That is still hearsay.
It is hearsay. I think it is very close in this case because that hearsay and that clinical experience is forming the basis of her opinions, which is allowed under MRE 702 and 703. So I will allow it.
So can you, in your expertise as an OBGYN, can you talk about what are some of the experiences that you have had in women's health regarding coercion?
So my direct experience in women's health regarding coercion has been to ask patients whether they were being coerced in a situation of domestic violence, trafficking, prostitution, especially where they came in with signs of abuse.
Now, if we can go ahead and turn to, well, before we move on from that, go ahead and look at page 23 of Exhibit 4. Let me know when you're there.
Yes.
So this is the section of the information that allows patients to locate a free or low-cost clinic to obtain ultrasounds. Is that correct?
Yes.
And there was, well, I guess let me rephrase the question. So some of these clinics, it was described yesterday, might be known as crisis pregnancy clinics on the next page.
Yes.
And it's been said that crisis pregnancy centers that provide ultrasounds are dangerous to women's health. How would you respond to that charge?
I'm sorry, repeat the question.
Sure. It's been said that crisis pregnancy centers that provide ultrasounds are dangerous to women's health. How would you respond to that charge?
I would say that, in my opinion, that is not true.
And it was stressed that the importance of having physicians read ultrasounds. What is your opinion about the importance of having a physician read an ultrasound?
I think that it is very helpful to have physicians read ultrasounds because they can confirm the sonographer's impression. Typically, there are two impressions. There's the sonographer's impression, and then the physician gives an impression specifically about things like, is there a fetal heartbeat and what is the gestational age?
And what is your opinion on whether or not these crisis pregnancy centers have physicians to interpret ultrasounds?
Objection foundation. That's not.
We'll go
an
ahead and
opinion
establish
question.
some foundation for that. Do you have any experience working with crisis pregnancy centers?
Yes.
What is that experience?
So in 1998 and 1999, I was engaged in private practice. And my office was in the same building, but not in the same suite with the crisis pregnancy center. And so if they had patients who came in who were considering abortion, I would do an ultrasound for gestational age and fetal viability.
Now, have you maintained contact with crisis pregnancy centers?
From a clinical perspective, no.
What is your experience, though, as a medical professional with whether or not these ultrasounds are reviewed by a physician?
Objection. I still don't think there's any foundation for these questions. She hasn't worked in a CPC, as I understand, hasn't worked year one in 25 years. I don't think I heard any testimony about any of these medical facilities in Michigan. Mr. Askinson?
Sure. There was plenty of testimony by Dr. Bagdasarian about hearsay that she had heard within her circles of physicians. So I think I'll just ask this witness. Within the circle of her physicians that she has heard, what are the reputations that you have heard of?
The limiting factors that I will put on that is if you can ask her about physicians that she's spoken with in Michigan, if she has experience and any relationship with crisis pregnancy centers in Michigan, and keep it relevant to maybe either this list and a relevant time frame as well.
Do you have any understanding of let me rephrase the question. Do you have an opinion on whether or not in Michigan there are physicians that are available to, and this is just asking her if she has an opinion. If she has, do you have an opinion?
Before you ask her about her opinion, can you ask her if she has lay the foundation of that knowledge first before we get to the opinion?
I'd like to ask if she has an opinion and then ask her for the foundation for that opinion. So do you have an opinion on whether or not crisis pregnancy centers in Michigan have physicians available to review ultrasound?
Yes.
What is the basis of that opinion?
I don't work directly with crisis pregnancy centers, but I know the directors or the director of crisis pregnancy center, and their name is escaping me at the moment, but I know that they have sonographers doing the ultra.
Still don't think we have a foundation for this testing.
I'm going to give her a little bit of leeway to explain what her foundational basis is.
So they have sonographers who do the licensed sonographers who do the ultrasounds and physicians who review those. I know that from my acquaintance with these directors and the activities. And then in addition, if you look.
I'm going to interrupt you for 1 second,
Sorry.
Doctor. Mr. Astinson, can you have her narrow it to applicable in Michigan and time frame as well?
Sure. What's the time frame of this exposure to child?
Doctor, I'm looking for who have you spoken with? When did you speak with them? What forms the basis of your understanding?
Okay. All right. I think I understand. So I think I understand now. So I will periodically do a webinar for crisis pregnancy centers on specific clinical topics. I think I've done 2 of those. And in that process, the crisis pregnancy centers will talk about the services that they offer. And they, I'm sorry, I'm blanking on the name of the person, but it was in Michigan. They offer ultrasound by a sonographer, which is read by an MD. And then in addition to that, looking at the websites for crisis pregnancy centers and the services that.
I'm going to allow it because I'm still trying to have her lay the foundation of her understanding before she provides her opinion. Please.
Thank you, Judge. So looking at this list of crisis pregnancy centers, if you look at their websites, they describe having sonographers. It's not all of them, but some of them describe having sonographers and that ultrasounds are read by a licensed physician.
In your opinion, the 24-hour waiting period, is that consistent with standards of informed consent?
Yes.
When you provide, when you consent patients, about how long does that process take?
The actual sitting down and talking with patients occurs in the context of a clinical encounter, which could be, half an hour, 45 minutes. But that process occurs over a period of days. And the reason for that is getting back to what we were describing earlier, which is that informed consent is not simply signing paper. It is patient coming to see you, talking about what her clinical issue is, identifying what is the optimal intervention, doing screening, providing patient education, and then signing the consent form. And that typically takes place over a period of time, even with urgent surgeries. It's different for emergency surgeries, of course.
And In your medical experience, is there any benefit to allowing patients to review materials outside of the context of a doctor's office?
Yes, and one of the reasons for this is that patients are often distracted or feel very stressed out. And there's objective evidence for this because you can measure a patient's blood pressure in the office and it'll be really high, like, well, you have hypertension, but then when they measure it at home, it's normal. And that's a phenomenon called white coat hypertension. And so often I've had patients come back to me or call me or email me and say, can you review what you said? I didn't absorb anything because I was so overwhelmed with the diagnosis or uh, uh, whatever the situation was.
Right, that testimony, Your Honor. My objection is both as to the relevance of it. These are not situations in which Dr. is consenting patients for an abortion procedure. She said that already. And it's also hearsay, once again.
Your Honor, I think we've been round and round this. This is based on her clinical expertise and experience. I have limited the scope of my question to procedures that she has done. Now, some of those procedures are technically similar to abortion. Dr. Wubenhurst would not define them as abortion, but some may define those as abortion. Some may define them as abortion in that she conducts procedures to preserve the life of the mother, which some people would consider abortion. Dr. Wubenhurst does not, but she does perform those procedures, which are technically similar to abortion, but based on her definition of termination of pregnancy versus abortion, it's not abortion because she takes into account that a procedure that is done to save the life of the mother is not an abortion.
I'm going to allow the doctor to testify based on her clinical experience.
Thank you. And just to be clear, what kinds of procedures have you performed that are technically similar to abortion?
So the ones that I performed that were technically similar to abortion have been suction D&C in the first trimester for a demised fetus.
How
Induction.
would that vary from an abortion procedure?
The baby was demised as opposed to the.
But medically, would there be any difference in what's done with instruments and so forth?
No, you would perform it in the same way.
Okay, continue.
In the second trimester, I have induced labor in patients who were sick or septic, who had to be delivered. Sometimes while the baby still had a heartbeat. That was to save the life of the mother. I think I mentioned earlier that I have done a procedure to surgically remove the fetus also in the second trimester.
What is there a name for that kind of procedure?
Typically, it's called dilation and evacuation, but in this situation, the fetus was demised. Or in these different situations, the fetus was demised. And then in the late second and early third trimester, I have performed inductions for either severe preeclampsia, where we simply could not control the blood pressure, or for where a woman was infected.
And did you obtain consent during that process?
Yes.
In non-emergency situations, is the 24-hour period more or less time than a typical patient will have between initial contact with a provider and having the procedure performed?
It's less time, if I'm understanding you.
What are frequent times for those procedures?
Well, I can give you a very specific example. For example, a lady who, this is in my clinical practice, women that I can speak to with personal knowledge, a woman who came in, or women who have come in where they began bleeding. I scanned her this is in the first trimester, there was no fetal heartbeat. I talked to her about the fact that, I'm sorry, you've had a miscarriage, and you can wait until you expel the fetus naturally, or we can proceed with surgical D&C. Some women will opt for surgical D&C, someone will opt to wait. If they have made the decision to proceed with surgical D&C, then I will do screening, check their blood count, make sure they're not excessively anemic, make sure their coagulation profiles are normal, give them some patient education material, because of course this is really difficult. You know, they had this miscarriage, they were thinking already ahead to who this child was going to be, and then schedule them for the OR. And in a non-emergent situation, that can take a week, or depending on the availability of the OR. And then they would come back to actually sign the consent form.
So in that process, there would be 24 hours to provide the information, the DHHS materials, in a way that wouldn't obstruct the scheduling of the procedure. Is that correct?
No, and in the absence of an emergency, I can think of very few situations where I have taken a patient to the OR or performed a procedure within 24 hours.
And to clarify, you said no, in that there wouldn't be any obstruction to the process. Is that what
Obstruction?
you?
Oh, you mean an
Obstruction to-
impediment?
Impediment to the process of scheduling a procedure.
No, this is how surgical practices work.
Now, go ahead and look at Exhibit K6, if you would. And actually, I'm sorry, K7.
I think I'm there.
All right, this is Northland Family Planning Clinics. It's already been admitted. Their consent for abortion procedure, medical procedures, and anesthetic services. Can you look at point number 4 on that form down there at the bottom? Looks like it requires some initialing.
Yes.
What does it state?
It states, I understand the type of ultrasound performed at the facility is done to determine length of pregnancy only, all caps, comma, and that the ultrasound may range +/- 2 weeks. I understand the ultrasound today will not diagnose any other conditions such as maternal or fetal abnormalities, ectopic pregnancy, pregnancy outside the uterus, sex of the fetus, a very early pregnancy, comma, etc., period. I understand that further testing may be required to determine pregnancy or to follow up on any unexpected findings that suggest there might be a risk to my health, period. I also understand any additional testing, comma, whether at the facility or with another provider, will be at my own expense.
And so if this is true, if the ultrasound may range ±2 weeks in dating and creating a gestational dating, how would a 24-hour waiting period would it affect what abortion procedures are available to a patient?
As described here, I don't think that it would, the 24-hour waiting period would affect the choice of procedure. And typically, D&C procedures are used up to 12 weeks, 13 weeks, depending on the comfort of the abortion provider. But
What type of procedure was that?
D&C procedures, suction,
Okay.
curettage procedures are used, and then, but they can be used at higher gestational ages as well. And then the dilation and evacuation procedures, which involve dilating the cervix, rupturing the amniotic sac, and then removing the fetus, start to be used later on in the second trimester.
Now, You have used ultrasound in the past, is that correct?
Yes.
And can we ever get an absolute, without, date the gestational age of a fetus absolutely within a 24-hour range?
I don't think so. And the reasons for that are that even when you have early dating with ultrasound, we always compare that to the last menstrual period. That has to do with the fact that women don't know for certain when they conceived, and there is variability in the growth rate of a fetus. And so there is not a correlation to within one day, 24-hour period.
And so as an OBGYN, you understand the different, that complications with abortion or risks with abortion can increase the later in a gestational period of a woman is. Is that correct?
Section leading. I think he's trying to lay the foundation for his next question, so I'm going to allow it.
Sorry, can you repeat? Yeah.
Sure. So with gestational dating, let me rephrase the question. So are there increased risks associated with either miscarriage or abortion later in pregnancy?
Yes, the risk for actual mortality, not just morbidity, increases 38% for each gestational week. Right.
And can you define those terms, morbidity? And
Sorry. So morbidity refers to injury or illness, and mortality, of course, refers to death.
now, do you believe that the 24-hour waiting period would actually change the procedures that are available to a patient seeking an abortion?
I do not. And I think that also you would need to have that.
And with the ultrasound dating, is there a margin of error?
Yes, as outlined here.
And could ultrasound dating be more precise than ±2 weeks?
I think, as I was saying earlier, we will compare an ultrasound date with the gestational age dating by last menstrual period. If that last menstrual period dating is within a week of the ultrasound date, we go with the last menstrual period.
Now, I'd like you to turn to Exhibit G, which has previously been admitted.
I am there.
And go ahead and take a look at the second page. It says resources at the top.
Yes.
It says, if you're feeling overwhelmed, confused, or simply unsure what is the best decision for you at this time, you may find the pregnancy options workbook helpful. Do you see that?
Yes.
And then we'll go ahead and look at the pregnancy options workbook, which is the next exhibit. And if you turn to page 12 of 116, it
Yes,
says,
I'm there.
giving yourself time and space to think. Do you see that section?
Yes.
Do you think that's consistent with the 24-hour waiting period? Giving patients time and space to think about their decision?
Yes.
What are some of the reasons that someone might need time and space to think about their decision?
Well, I think they described them here in the other column. It says, but remember, this decision will affect the rest of your life. Abortion is an irreversible decision. It impinges on something that is very fundamental to human existence, and which is having children. And then it goes on to say you owe it to yourself to take time. And when you were pregnant, time makes a difference. So I think that that is giving some reasons directly here why women would want to think about that. I think there are other potential reasons as well.
Go ahead and look at Exhibit I. This again is from Northland's website. It says pre-abortion instructions. Do you see that?
I think I'm on the wrong page. Hold on.
Sure. I as in igloo. I think you're in K's there, or J's.
Yes. I'm here.
So it says before your appointment. Do you see that
Yes.
information? What are the two criteria or restrictions there?
It says, bullet point, no aspirin products for 48 hours before your appointment. Second bullet point, no street drugs, marijuana for medical use, or alcohol for 24 hours prior to your appointment.
And so what would the purpose of those things be?
For the restriction on aspirin products, it's because aspirin decreases the ability of blood to coagulate. So when you do surgical procedures, it's pretty standard to tell patients to refrain from using aspirin or ibuprofen or similar drugs because it can be associated with excessive bleeding during or after the procedure.
Why would that be important for abortion procedures?
Because you want to minimize the risk of hemorrhage. And hemorrhage is a known complication of abortion, and you want to protect the patient from that adverse outcome.
If a patient took aspirin before a procedure, in certain circumstances, would it be appropriate to delay the procedure?
Yes, and actually, in the hospitals that I've worked at, we would ask the day of surgery, have you taken ibuprofen? Have you taken aspirin? We actually would do urine drug screens as well, too, speaking to the second bullet.
And so if someone had taken aspirin and it came back in well, how would that affect the ability of the individual to have that procedure that particular day?
Well, I'd be worried, especially about procedures where there is significant risk of blood loss, because you don't always just worry about bleeding during the procedure. Most bleeding actually occurs after a procedure. And if they have an impaired ability, if the ability of their blood is impaired, to coagulate is impaired, then that can lead to complications as well as oozing at the surgical site, and that can lead to infection.
And so if someone had had aspirin before a procedure, could that be a justification to delay the procedure?
It would depend on the procedure, but it certainly could be, yes.
And that delay could be 24 hours or more?
Well, I think they've stated previously, we prefer to wait 48 hours because aspirin actually, its effects on the coagulation system are very quick, within 30 minutes, and then can last as long as.
I'd like to talk about coercion for a little bit. And you go ahead and take a look at Exhibit 7. You have served underprivileged communities throughout your career, is that correct? And what impact does coercion have on those communities or in those communities?
I think it's very important because coercion is a manifestation of child sex abuse, adult sexual abuse, domestic violence. section. So it has a very significant impact on not just women, but communities, in that they, women live in a state of fear, and in the case of trafficking, in a state of enslavement.
And, I told you to turn to Exhibit 7, but I'm going to ask you to turn back to Exhibit 5. Have you ever observed documents? Go ahead and take a look at this. Have you ever observed documents like this before?
Yes, I have.
And what context?
The context is that in health facilities, you put signs in the bathrooms, signs in the waiting rooms saying, if you are being abused, here's a number that you can call confidential.
And would it be a burden on patients to have those signs in literature?
No, not at all. In fact, I think it's our responsibility to do everything we can to help patients escape coercion.
And would you say that's the case for women's health generally?
Yes, I think it's especially important in women's health because abusers may not take their, in my experience, abusers may not take their, the person they're abusing to get their blood pressure checked or to get medication. But if they are pregnant or they have an STD, sexually transmitted disease, that is the one time that they will take that woman in to be seen. And so that is a unique opportunity for OBGYNs and nurses to screen for coercion and to assist the woman, if she's ready, assist the woman in getting out.
All right. Go ahead now and take a look at Exhibit 7. Have you been able to review this document before?
Yes.
And this is the screening for coercive abortion, intimate partner violence, and domestic abuse screening tool and protocol for abortion providers. I'd like to kind of go through the numbered bullets just briefly, 1 through 3. Do you see those?
Yes.
So the first one is create a safe environment for asking screening questions. Why is that important in coercion screening?
Because typically abusers will not allow person that they're abusing, the woman in this case, to be alone with the provider.
And just to lay a little bit of foundation, have you ever conducted coercion screening in your career?
Yes.
How often do you do that?
We screened for coercion in 100% of patients in the hospital where I'm practicing. And my previous practice was to screen for it in every patient that I saw.
And so point 2 is normalizing the process. Is that good advice?
Yes.
Why is that good advice?
Because the more you as a physician are acquainted with going through this process, the easier and more natural it will be, and the more easily you'll be able to communicate with the patient. And in addition to that, when you're developing a relationship, a clinical relationship with the patient, they are trusting you to help them with whatever problems are going on in their life. And this is a huge problem that's going on in many people's lives.
I would like you to go through the next section, part
Okay.
3.
Dr. Rubenhurst, can you try to keep the microphone closer to you?
I'm sorry.
I know that's.
I'm sorry. I'm not used to talking
okay.
to a microphone. Is that better?
Yes.
Okay, great. Actually, when I can hear it in the room, that means that it's okay.
Yes.
Good. That's helpful. That's helpful.
Very good.
Thank you.
So point 3 here is.
Can I just
Yeah, of
make an
course. Sorry.
additional point here? I think the other piece here is that very often physicians are uncomfortable talking about coercion. And so by normalizing the process, it helps people to become more comfortable with having those discussions.
I'd like to talk about the section that's entitled Ask the Screening Questions. So to help the client, it goes on to say this, to help the client become comfortable in asking these screening questions and build rapport with the client. The screening for coercion and an intimate partner violence may be incorporated into the general discussion of her reasons for the visit, health history, and risk screening. Is that good advice?
I think it's excellent advice, and it's similar to what we do with screening for depression and suicide, for example.
And the screening questions should be clear and direct. Why is that important?
Because what I've found in talking to people about these very difficult and sensitive issues, it's how you ask the question. And when you beat around the bush and you're, sort of hesitant asking the question, people become suspicious. Like, why are you not being open with me? Why are you not being direct? And so I think that asking the direct question, but asking it in a gentle and compassionate way, helps the patient to realize, okay, this person's listening to me and I have a problem. For many women, abuse is normalized in their lives. And so for them to hear from someone, it's not okay for you to be beaten. It's not okay for you to be raped. It's not okay for you to be trafficked. They may not have thought of it in those terms. And so asking directly often opens their understanding to being able to answer that question and consider, hey, there's something wrong with my life right now.
And then it says screening questions should be incorporated into the standard medical record. Suggested questions include. Can you go through and read those suggested questions?
You want me to read them aloud or read
Sure.
them to myself? Okay, number one, have you told any of the important people in your life that you were pregnant? If so, how did they respond? Has anyone forced or pressured you to come here today? Does the person who got you pregnant know you are here today? Are you afraid of what someone might do to you if you don't do what they want with the pregnancy? Has anyone threatened to hurt you or made you feel unsafe if you don't have an abortion? Has anyone threatened to harm you legally or financially if you don't have an abortion, like threatening to have you arrested, deported, or destroy your legal documents, or threatening to get you fired, kicked out of your home, or taking away your financial support? Are you in a relationship with the person who threatens or physically hurts you? Do you feel you are in an unsafe living situation? Have you been hit, slapped, kicked, or otherwise physically hurt by someone in the past year or since you have been pregnant?
What is your opinion of these questions in the context of screening for coercion?
I think these are all helpful questions, and I've seen very similar questions used in sort of standardized coercion screening documents.
And I note that it says suggested questions. Should a provider be following a script or how should that process go?
I think that thinking about these questions, again, similar to what I was saying earlier with depression or suicide screening, thinking about them and even practicing the questions with yourself helps people to become comfortable with it. But there's nothing negative here. I think that these are just helping people to think in a consistent way about how to screen for coercion.
And do you believe that it is a benefit to providers to have information like is contained in Exhibit 7?
I think so, because I've said sometimes physicians have related that it can be difficult to start these conversations, and giving them an on-ramp to be able to initiate the conversations and think about how they would ask these questions. It doesn't have to be prescriptive, but it gives you a way to incorporate these types of questions into your clinical interview process.
And in your experience, how would that benefit the patient?
Because as I've said, patients have said to me, you're the only person who's ever asked me if I was being abused. And of course, you approach this compassionately and gently, but if you don't ask, you'll never know. And I think that the evidence is very clear that in domestic violence situations, in trafficking situations, in child sexual abuse situations, abuse tends to escalate, whether they have an abortion or not. Abuse tends to escalate. Abuse tends to escalate in pregnancy. And we don't want these women to end up in the hospital from having been beaten or being killed. the leading cause of maternal mortality in non-medical cause of maternal mortality in many states is homicide. And so that is an outcome of coercion and abuse.
And why do you think that it's important, specifically in the state of Michigan, to conduct this coercion screening?
Because Michigan has been identified by the AG's office as a state where domestic violence is relatively common. I already mentioned the study by Glander et al. That I mentioned in my expert report that showed that 40% of women seeking abortion are victims of domestic violence. And then in addition, Michigan is in the top 10 states out of 50 states and DC for sex trafficking. I'm sorry, for human trafficking and sex trafficking.
So the law instructs the provider to assess a patient's current level of danger. Why is that important?
It's very important because if it's a situation where there are weapons involved, especially where there are children, where violence has been escalating, that woman is at very high risk of homicide.
Why would it be important to explore safety options with the patient?
Because for many women, they can't just leave and they often need instruction. I've seen in my practice where women tried to leave and had just disastrous consequences. They often need a plan and they may not be ready to leave. This is a significant thing. They may say, okay, I've got kids. What am I going to do with my kids? Where am I going to live? How am I going to get away from this person? And so helping them to develop a safety plan is one of the most valuable things we can do, especially in the setting of escalating violence or where there are weapons involved.
Is it important that doctors report domestic violence or coercion to abort for patients under the age of 18?
Yes, because by definition, child sexual abuse is a crime, and child sex under 18 is by definition non-consensual. So that there's an immediate need for assessment, especially because very often the person who is bringing a child for medical attention is their abuser.
Your Honor, at this time, I'd like to ask for a brief recess. I have one more topic, or a couple more topics actually, to go over with Dr. Rubenhurst. But I think now would be a great time to break for lunch.
How much longer do you think your examination will be?
I think it's gonna probably be another 45 minutes. So if we can take a break now, I think now is a convenient time to do that.
Obviously, Your Honor, we'd prefer to finish. There's an outside chance. I know how long our cross examinations are going to take. Combined, probably have less than an hour and a half. If there's any way to get done today, we'd love that. If it's possible to take a shorter lunch break, if Mr. Aspenson needs it now so he can get his thoughts together and prepare, that's fine. But if we could do it shorter and then not take a bunch of breaks, like before we end her direct, and instead take the break that they want now, totally fine.
Your Honor,
It is.
we've been going at a breakneck speed. My initial estimate for this trial was a 5-day trial. I didn't object when opposing counsel said we could do it in 3 days. I have 2 witnesses, Your Honor, to put on. I'm a little bit uncertain why we keep being urged to move this trial forward at a breakneck speed where we're not taking lunch breaks to just allow us and the witnesses to recover. I understand that they can swap out attorneys one after the other. That's great. But I would just ask for the courtesy of a lunch break, Your Honor.
I think we will take a lunch break. It is noon. But I also want to acknowledge that there's the other side of is that we had anticipated, and I think everyone here, other than myself, anticipated that this would be a 3-day trial. We are on day 4 and it is noon and we haven't finished the direct examination of Dr. Rubenhurst yet. So I want to be mindful of the competing interests. Let's take a lunch break. Let's do a 45-minute lunch break and then come back at 12:45.
Very good.
Court claims is now.
Back, everyone. Please be seated. Dr. Rubenhurst, you're still under oath. And Mr. Aspenson, you may continue your direct.
Thank you, Your Honor. Dr. Rubenhurst, I would like to talk next about the physician-only requirement under the law. Can you go ahead and take a look at Exhibit D?
Yes, I'm there.
All right, and on the second page, at the top of the page, it says, first trimester abortion is considered one of the safest outpatient procedures when performed by trained physicians. Do you believe that it's important to have trained physicians provide first trimester abortions?
Yes.
Would that be similar reasons to why it is important to have trained physicians conduct ultrasounds of patients?
Yes.
If we go down to the second trimester abortions, again, we're on Northland's website, it says a surgical abortion performed at a trusted second trimester clinic is the safest and only option for those seeking an abortion 15 to 24 weeks into their pregnancy. This procedure is considered one of the safest outpatient procedures when performed by trained physicians. Again, at the second semester stage, is it your belief that these procedures should be performed by physicians?
Yes.
And is it your position, reading these documents, what would your interpretation of the physician, would these documents be or statements be consistent with a physician-only requirement?
Yes.
Why?
You mean because of the wording? Is that
Yeah,
what you're?
yeah.
Right, because they're clearly stating that trained physicians are the ones who can safely provide this procedure.
Now, have you worked with APCs?
Yes, very extensively.
And based on your clinical work and your research, what is your understanding of the current education system that would prepare APCs currently? And I guess, what is your understanding of how the current education system would or would not be able to prepare APCs to perform abortions?
Well, I think there are two parts to that. Part is that their educational system, the educational systems for APCs, most of them do not include didactic training for abortion and do not include hands-on training for abortion. More important, they don't have training in managing the complications of abortion. And so that's one reason I have tremendous respect for APCs. In fact, I mentored them and taught them. I have taught them at different points in my career. But the requirements for APCs, insofar as their educational requirements and clinical requirements, are far less than for an OBGYN board certified physician.
Can you give us some practical examples of that?
Of how
How the education differs between those?
Sure. So typically, depending on the type of program, whether it's nurse practitioner, physician assistant, or clinical nurse midwife, some people can enter those programs with an associate's degree and then go on to have their training over the course of typically 3 years. Because APCs practice over a wide range of clinical areas, for example, medicine, pediatrics, so on and so forth, their focus is general. It's not specifically in women's health and obstetrics and gynecology. In contrast, physicians have a 4-year baccalaureate degree, 4 years of medical school, and in OBGYN at present, 4 years of residency. So during the 4 years of residency, you have thousands of hours of training in surgery, management of surgical complications, and in dealing with not just surgical complications, but medical complications such as infection as well.
Are you aware of any studies that talk about APCs being able to perform second trimester abortions?
Yes,
Second trimester and DNC abortions?
yes.
Okay. What is your knowledge?
There's a study, and I'm sorry, I'm blanking on the name of it right now, which looked at, it was an analysis across different countries. And this particular study did mention that in some countries, APCs were performing second trimester abortions, which I do not agree with.
Are there any studies that, well, I guess the next question that I have for you is, how well do you believe that APCs could provide abortion care in rural areas?
I do not think that it would be appropriate, mainly because when people have reviewed complication rates from abortion, they are typically in the context of being near a hospital or a medical center that can provide emergent care. That is not the case in rural areas, especially right now, given the number of rural hospitals that are closing. And so the availability of a hospital that has an operating room, a physician who's capable of caring for the patient, blood, IV antibiotics, that facility may be pretty far away. I think the other issue is in simply recognizing a complication and understanding that this is something for which a patient needs to be admitted. If I can just add to that one more thing, which is that complications from abortion, the question isn't whether or not they're rare. The question is, when they happen, they can be catastrophic, and you need to know what to do right away.
And what are some of those catastrophic complications?
Things that I've personally seen in my practice are hemorrhage, infection, uterine perforation, damage to the bowel and the bladder, requiring bowel resection, and future risk of preterm birth.
So in what context did you see those complications?
These are patients that came in through the emergency room who were very sick. They had had second trimester abortions. They were septic. In one particularly noteworthy case, this lady had an abortion that I would estimate had occurred at about 18 weeks. And she came in and rapidly deteriorated. I scanned her. She had about 1 liter of blood in her abdomen and retained fetal parts. I could also clearly see a perforation. And so in that situation, your first concern is, is there bowel or bladder injury? So I took her to the operating room with general surgery, made a big incision, and they had indeed damaged the bowel in 2 places, and she needed a bowel resection. They had also left the fetal skull, the spine, and the right arm. And so I had to remove those and do a DNC, as well as to repair the uterus. And she had a very difficult postoperative course. She had renal failure, she had liver failure, her coagulation studies were abnormal. She had to be transfused. And this is one of the worst cases I've seen in my career. I've also seen complications from first trimester abortion, women hemorrhaging or having retained fetal and placental parts.
In your experience, has proper oversight of medical providers ever been frustrated by advocacy concerns?
Yes.
What are some examples of that?
I can think of two examples. One is the eugenics movement, and the second is the opioid crisis.
And what experience do you have researching the eugenics movement?
As I think I mentioned earlier, I'm writing on this subject. I have done probably weeks of research, including going to primary source material in places like Massachusetts to look at original eugenics document. I probably reviewed the entirety of eugenics literature from about 1830 through 1945. I probably read a dozen books on the topic as well.
And would Buck v. Bell be one of those cases?
That was later, but it's one of the cases. And Buck v. Bell was basically a legislative response to the eugenics impulse that began in the late 19th century through scientific materialism and social Darwinism. And then that coalesced into the eugenics movement sometime around the end of the 19th century. What happened at that point was that the advocacy for eugenics began to enter into the medical field, as there was a sense in which people who were considered inferior, who were unfit, should be sterilized or castrated. And so that particular sentiment came into the medical field, I would say, in around the 1920s, and actually continued up until the 1970s.
And can you just give a brief explanation for how proper oversight of medical providers was frustrated by this advocacy for eugenics?
Well, because eugenics initially was both a scientific and a political and social movement, even when there began to be voices speak in the medical community and elsewhere speaking out against eugenics, those were drowned out by concerns about overpopulation, populations of people who should not reproduce. And you mentioned Buck versus Bell. That was really, really more than anything, simply the commodification of eugenics into legislative action. And what happened was that the advocacy, if you look at Buck versus Bell as a legal case, the advocacy began at the very beginning with this young lady who was clearly able to function socially, but was, because of her family, was condemned as being promiscuous and intellectually and liable to continue to get pregnant. As it turned out, she'd become pregnant through rape. But this provided the impetus for eugenics advocates and activists to push this case through the courts into the Supreme Court, resulting in that ruling.
And would you consider, well, you were a physician during the opioid epidemic, is that correct?
Yes.
Would this be another example of advocacy or medical providers provision of healthcare being frustrated by advocacy?
Very much so. So I had been in practice for a while. I think I would say this began about 10, 15, maybe even 20 years ago now, where we began hearing consistently, pain is the fifth vital sign. We're not treating pain adequately. We need to give patients narcotics for their chronic pain, ignoring the fact that most patients don't do well with narcotics for chronic pain. They need other pain control modalities. But there was a sense in which patients felt that their pain was not getting adequately treated. And so there was a lot of activism and advocacy. Then coming from the other side, there was impetus from pharma to increase sales of narcotics. What that culminated with was a change in medical practice where previously narcotics were something that you were fairly restrictive and selective, but liberalized those for a variety of both surgical and non-surgical applications. The result was the catastrophe that we're still dealing with of millions of people who have become addicted, many people who have died from overdoses, so on and so forth. And it wasn't until there began to be investigative journalism and then research coming in to say, let's look at what the prescribing patterns are. Why are we having these doses? That then it came to the attention of state regulators who intervened.
And one of your roles in North Carolina, I think you review some, well, can you describe kind of your role with licensing of physicians and so forth in North Carolina?
Yes, I review cases for the North Carolina Medical Board where there's a question of malpractice, or whether they're trying to establish whether it was malpractice in a specific case in order to help make a determination about whether that physician should be disciplined or not.
And are these regulatory systems designed to address concerns like the opioid epidemic, or rather, are they well positioned to be able to address opioid epidemic type scenarios?
I think they're at a secondary level because the concern of the medical boards is the practice of medicine or the practice of nursing. And so they are interested in looking at physician behavior. Are there specific problems with an individual? So they are kind of at the secondary level. It's not until a public health issue rises to the level of concern that the medical boards realize we need to take action, for example, in censuring or disciplining people who are prescribing excessive amounts of opioids. But that's fairly late in the process of something like the opioid epidemic.
So are you aware of any concerns in abortion practices with patients or employees underreporting issues?
Well, I think there's been a recent report where that was raised as a concern.
And what were some of those concerns?
Some of the concerns were that there were, in the context of abortion clinics in a number of states, that there were problems with high turnover, there were problems with morale, there were problems with staff being inadequately trained, especially in the intake areas and in such sort of routine and important activities like blood drawing. And that there was a sense in which employees were being told that they shouldn't complain or go public with these concerns because this was a time when they needed to not talk about this, a mission moment, so to speak.
How would you compare that to the opioid crisis?
I think that there was pressure, some subtle pressure and not so subtle pressure, as I said, from advocates. And again, I want to emphasize that I don't necessarily think that people initially having on the advocate side were trying to hurt or kill people. It's what it evolved into. But I think that from the advocacy perspective, it's very similar that when physicians spoke out and said, we're prescribing too many narcotics, something is really wrong. We have more and more people who are addicted. People not only become addicted, but then they turn to the streets when they can't get their drugs, the drugs that they want to get. And so I'm sorry, go ahead. Yeah. I'm sorry, can you repeat the question? I was distracted.
So these different reports and so forth that you have heard, what were some of the allegations?
The allegations were that employees were told not to bring I remember what I was saying before. So you were talking about how the advocacy could overtake the practice of medicine, right? So in that situation, even though people in the medical field like myself said we're prescribing too many narcotics, something is wrong. Not only that, but people are now taking all these narcotics that we're prescribing and selling them on the street. And that's leading to an explosion of illicit drug use as well. So the advocacy still was like, no, this is something that physicians are doing wrong. You should be doing X, Y, and Z. And so we allowed ourselves to be convinced that that was the truth. And that led to the situation that we're in now, where state regulators had to step in and address the issue.
So right now we're talking about, in large part, consenting patients. How long does that process usually take?
Well, as I was saying earlier, because consent occurs along a spectrum of discussion, screening, patient education, and then them finally giving you written consent for the procedure, it can take several days. It can take up to a week or even longer. Sometimes I've had patients who were scheduled for surgery, had their date, and then called me and said, can we talk about this? I'm still not comfortable. Are there other alternatives? And we were able to find other alternatives. That's not an infrequent occurrence.
And if they were spending, if medical providers were spending 10 or 15 minutes with a patient, would that be enough time to go through their options for surgery or for a procedure, a gynecological
No, I
procedure?
would never consider that to be adequate, especially in the context of an irreversible decision like tubal ligation. And in fact, tubal ligation, there is a standard form, a very rigorously defined process for women with Medicaid as their source of insurance to try to deal with what I was talking about earlier, which was the coercive sterilization.
And this report that we've been talking about also, the discovery of undertraining for medical professionals in intake. Is that part of what we're talking about here?
Very much so, because I think that you need to have skilled people. If you're going to divide up the job of patient education and screening, you need to have people who are skilled to be able to ask questions, for example, about coercion, about medical issues that they may have. This is a patient safety issue, and fundamentally, those issues revolve around patient safety.
And did this report say anything about the training of staff in states like about California?
I think California was one of the states mentioned, and they said that staff felt that because of high turnover and inadequate training, they felt that this was highly problematic in terms of the clinical services that they were providing.
And was this specifically related to abortion clinics?
Yes.
I'm going to object at this point. I'm not sure what report. Maybe really more of a foundation of what
Yeah.
the report is and where it was published.
By all means. So Dr. Wubenhurst, may I present a document to the witness?
You may.
Yes, this is it.
Yeah, I'm gonna move to strike all of this testimony. This is a New York Times article. This is not a peer-reviewed research study of any kind. This is not something that OBGYNs in the field would usually rely upon in expert page of the news.
You have a copy for me to look at?
Absolutely, Your Honor. So
Also, I don't believe this was on the exhibit list.
you're right. This was published 4 days ago, Your Honor. It was on the first page of the New York Times on this Sunday. This is current. It's about an 18-page article. This is a self-authenticating document, specifically under 902 sub 6, where newspapers are permitted to be used and self-authenticated. Expert reports may be based on hearsay. And this is an exception to the hearsay rule. And this really helps this court as a truth, it really helps the truth-seeking function of this court. Now, the amount of hearsay contained herein is something that this court is permitted to take into account in weighing this. But also, under Rule 203, the facts or data upon which an expert bases their opinion or inference, it says it shall be in evidence.
So,
Are you seeking to listen to evidence?
At
I
this
also
time, I
have a
would like-
question of whether you're saying that this is an article that she's basing her opinion on, or whether she actually has personal knowledge of, is this just an investigative article, or is there a scientific study underlying it? that
Your
is being
Honor,
reported on?
Your Honor, these are facts that the expert witness has testified that this is a similar type of document that medical professionals rely on in discovering what is going on in their profession, that she has testified that the boards are not equipped to handle. And so this assists the
You know what?
fact
I'm going
finding.
to take 10 minutes and go read this article, and then we can have a discussion about the admissibility and what relevance it has after I get back.
Thank
So
you, Your
let's take a
Honor.
10-minute recess.
We'll now reset. Kendall, do you have copies for the other defendants?
Absolutely.
May be seated. So before we broke, we had an evidentiary issue. I've had a chance to look over the document. Mr. Asmunsen, would you like to make an argument for why this should be admitted and used?
Yes, Your Honor. Your Honor, Enrique Castro, and that's 344 Mishap 590.
344 Mishap what?
344 Mishap 590 says that it is well established that an expert witness may rely on hearsay when the witness has formulated an opinion. In that case, the hearsay what had to do with different police reports and things like that that the expert had relied on in making their opinion. In this particular case, I discussed with Dr. Wubenhurst her belief that proper oversight of the abortion industry might be frustrated by advocacy. And we got into some of the details of that. And the question was put, what was the basis of that foundation? And we presented a self-authenticating document, a front page article from the New York Times from about 4 days ago. It was published in the Sunday edition. Newspaper articles are self-authenticating under 902 sub 5. So there's no issue with the authentication. And then if we look at 703, in conjunction with Enrique Casto, it states that facts or data upon which an expert bases their opinion shall be in evidence. And so this is not an issue of hearsay. It's not an issue of authenticity. It is an issue that this court can give whatever weight this court deems appropriate to a New York Times front page article. And this portion of Dr. Wubenhurst's testimony is that she did rely on that article, and it has, in the context of the opioid crisis, there was investigative journalism that helped to open regulators' eyes to what was going on. And this is the same kind of high quality investigative journalism that has indicia of believability and truthfulness to it. Now, whatever weight Your Honor provides to that is for you to determine. But I think that this information does help this court with the issues that are presented by this case. There's issues in that article where it talks about training of medical professionals. That is an issue with the APCs. There's been testimony that they will receive on-the-job training from clinics, and there's evidence that that is not of the same quality as perhaps Northland is engaged in when it provides training. And so this case is not a case that just impacts Northland. This case is a facial challenge to the constitutionality of the entire statute, not just as applied to Northland, but as applied to all clinics that provide abortion. And so I think there is some evidentiary value to Your Honor having the opportunity to take this into evidence. And again, whatever weight Your Honor wants to give the article is up to you. But I think that it needs to be before you to consider.
Thank you, Your Honor.
No, Your Honor.
Oh, I'm hearing argument on.
Oh, absolutely.
Yeah.
Absolutely.
Okay.
But Ms. Duane is the one who has this witness. She has been placing the objections. They don't get to double team me on this argument, Your Honor. I mean, I didn't complain about it yesterday, but the person who is objecting to the witness is the one who also needs to object to or provide argument on the other side of my evidentiary issue, which deals with this particular witness. They're not allowed to change attorneys midstream.
Asmunsen, I think that Ms. Duane has been taking the questioning with this witness, but there's no question that Ms. Kelly is lead counsel, one of the lead counsel in this case. So with this evidentiary issue, which I think is very important, I'm going to allow whichever attorney that they choose to argue the opposition for me.
Thank you, Your Honor. This article is hearsay. Whether it's authentic or not doesn't change the hearsay rules. Michigan appellate courts have held that newspaper articles are not admissible precisely because they are hearsay. I would direct Your Honor to People versus McKinney. It's 258, Mish App 157. The court there stated from 2000.
Can you say that again? I'm sorry,
Yeah.
258.
258 Mish App 157 at page 161. And what the Court of Appeals stated there was, we acknowledge that the two articles were not included in the record and that the court cannot take judicial notice of a newspaper article for the truth of the matters asserted therein because of the general prohibition against inadmissible hearsay. Correct, Your Honor. There's also, I would direct Your Honor to Edwards versus Detroit News, 322 Mish App 1 at page 4. Authenticity is not the only prong of admissibility. They have identified no hearsay exception under which Your Honor could admit this. In terms of the expert reliance, 703, if it operated the way Mr. Asmunson is proposing to the court, it would swallow the hearsay exception in whole. There would be no point for a hearsay exception if all you had to do was feed every hearsay document to an expert, they relied on it, and suddenly it all comes in. It's simply the rules of evidence don't work that way in practice. More problematically for Dr. Rubenhorst are the requirements under 702. 702 requires that an expert has to apply specialized expertise to arrive at a conclusion or opinion that the finder of fact, typically a jury, is not equally well suited to make. In coming to that opinion, an expert under 702, which is analogous to Federal Rule 702 in the Daubert standard, has to use a technique that is generally accepted in the relevant field. Here for Dr. Rubenhorst, it's obstetrics and gynecology or medical research. It is absolutely not accepted within the field of obstetrics and gynecology and medical research to simply look at published newspaper articles. Moreover, the argument that she needed this to come to her opinions is belied by the timing. As Mr. Asmunson told you, this came out on Sunday. Dr. Rubenhorst's opinions were laid out and set forth in her declaration and her deposition, all of which were fully formed before this came out. There has to be some specialized or technical knowledge being applied through a generally reliable methodology that's accepted by others in the field. Simply having Dr. Rubenhorst put into the record what some journalist found in a New York Times piece and published in hearsay is not doing that. If, for example, this was admissible, which it's not, Your Honor is as equally qualified as Dr. Rubenhorst to read and analyze whether the New York Times did proper investigative journalism. There's no specialized knowledge or technique that Dr. Rubenhorst is using in interpreting this data. And that's what has to be done in order for an expert to opine about something under the Daubert standard. So it's not separately admissible on its own. Dr. Rubenhorst's testimony is about this isn't permissible under 702. And we would ask Your Honor to deny the request to admit this and strike the entirety of Dr. Rubenhorst's testimony, which I'm sure at this point goes back a few pages about the report she was talking about.
Yes, Mr. Payne. Give me one moment. I just want to find site. Do you have a page citation for your citation to pick people?
I do, Your Honor. It's page 161, note 4. And I'm sorry, the quote I read is from Edwards, which is 322, and that was citing People versus McKinney. So Edwards is 322, Mish App, page 4 from 2017. Sorry, 2.
No.
Oh, note 2. I apologize.
So in
So to make it simpler, Your Honor, because I've now totally muddied the record, if Your Honor is pulling something up, I would ask Your Honor to pull up Edwards versus Detroit News, Inc.
and that's 322 Mish App 4.
It's 1, but it's at page 4.
Okay.
I apologize for gunking up the works here.
What were you citing?
Yes, footnote 2, we acknowledge that the two articles were not included in the record and that the court cannot take judicial notice of a newspaper article for the truth of the matters asserted therein because of the general prohibition against inadmissible hearsay. Yes, Your Honor.
All right, Mr. Ping, thank you very much.
Thank you, Your Honor. So defendant Hertel joins in plaintiff's objections here, but I also wanted to add on some objections under rules 402 and 403. You know, even taking the assertions in this article as true, although it looks like we're not going to have a chance to look into that, it reports that Planned Parenthood sees 2.1 million patients per year, yet the article comprises a handful of anecdotes. When it does make assertions generally, those are heavily qualified. The word Michigan does not appear anywhere in this 3,700 word article. So, you know, I think even very early on, after stating that the review was fairly comprehensive, the article concludes that only some clinics are so short of cash that care has suffered. So I really don't think that this is relevant to care in Michigan. That inference can't necessarily be drawn. Related, I haven't had a chance to confer with my clients about this. I rely on my clients' public health expertise to to make these arguments. So that might not be the kind of prejudice that's contemplated under 403, but I think it's very relevant to the exercise of your authority on whether to admit. And I think those same concerns about the prejudicial effect of this non-specific information that is largely anecdotal also implicates the 702 arguments that counsel has already made. Thank you.
Thank you very much. Is there any other defendant other than interviewed that would like to make an argument? No, that is fine. Mr. Aspenson, you have rebuttal?
Dr. Wumenhurst testified that she is part of regulatory bodies in North Carolina that oversee physicians and their practice. And she also testified about what went on during the opioid epidemic. She has specialized technical knowledge. That specialized knowledge right there is her participation in the regulation of medicine. And her ability to opine on these matters is what we're asking for the court to consider. Now, that opinion that she is making from that vantage point is what's relevant to this court. It's the reason why it's the reason why we are arguing that there needs to be these laws in existence to provide that regulation and that oversight, because the bodies themselves are not adequate to do that. And that's what Dr. Wumenhurst is testifying, and she is relating it to other past problems. And so I think her specialized knowledge is that ability to relate it. It's not that I'm just trying to put this article in front of you. It's her ability to analyze this article compared to other articles that came out during the opioid crisis. Because as Dr. Wumenhurst testified, there was reporting that helped to uncover what was going on and helped to uncover the opioid crisis. And so it's that specialized knowledge that we're relying upon. I would state that the Edwards case is a defamation case where there was a request to take judicial notice. I'm not asking for judicial notice in this case. I'm asking for this court to accept facts and evidence that the plaintiff relied on, which is an exception to hearsay in and of itself.
So one of the issues that I am having with this article, and maybe you can expound on this, is the article itself, even if I can take judicial notice of the fact that this article exists, it's filled with hearsay within hearsay. And you are, at least my understanding is that you're using the facts or the investigative reporting that is contained within this article as a factual basis for Dr. Wumenhurst's opinion. So can you address the hearsay within hearsay issue?
Well, I do believe that it is well settled that an expert may rely on hearsay. And so,
So it is, I agree with you that they can rely on hearsay. However, they have to be, it has to still be based on sufficient facts and data. And I guess if we're gonna parse it out, the distinction between relying on a New York Times investigative piece or newspaper article versus relying on a peer-reviewed journal, correct? And both would be hearsay, but the reliability of one is significantly different than the reliability of the other.
and Your Honor, I think that would go to weight, not admissibility. And I think that studies are going to have hearsay within hearsay as well. You're potentially going to have an interviewer who is taking the interview of a subject and then recording that.
But there's a
And-
specific exception, like there's a specific hearsay exception that covers the entirety of peer-reviewed journal and articles, right? The newspaper article exception does not do that.
Which exception are you talking about with?
Which one are you relying on to argue for the admissibility of the
I
newspaper?
rely specifically on In re Castro, which states it is well settled that an expert witness may rely on hearsay evidence when the
Ray
witness,
Castro, they were relying on expert reports. That's the hearsay that was at issue in
they
Ray
were
Castro.
relying on CPS reports.
Correct.
And so those CPS reports are hearsay and hearsay within hearsay because you have someone recording that.
I don't think that that's a relevant enough analogy to a newspaper article.
Well, I think it's similar to a reporter relying on statements that are made by the person that they are speaking with. And because when the issue were statements that were made to CPS, and so the expert relied on the statements that were made to CPS. And so you do have a double hearsay there as well. You have, it's being offered for the, it is being relied upon by the expert, and the statement is a statement that's made to CPS and then that the expert is reviewing and relying upon.
In Ray Castro, the reports at issue were expert reports that had been made or that had been put together in a case specific to the litigation that was at issue.
Court's indulgence for one moment. I'm looking specifically at asterisk 617. It kind of splits, that page number kind of splits what we're talking about here. And it said, and maybe I need a little bit more context, but the doctor relied on Orr's statements to CPS. And the minor made disclosures to Orr, ORR. And for that, the court said it's well settled that an expert witness may rely on hearsay evidence when the witness formulates their opinions. So and I will fully acknowledge that I haven't had a tremendous amount of time to read the whole case, but my reading of that sentence is we do have double hearsay there. And that the experts report, this isn't a backdoor way to get this in.
Well, it kind of is because, and I want to take a moment to talk about In re Castro since you are relying on it very heavily. If you'd like to take a few minutes to read the case and we can come back and talk about it in more detail.
Sure.
My distinction is that this is talking about reports that were prepared by an expert based on conversations and the things that were done in preparation for that litigation.
Okay, if I can
And-
have a moment. then.
Sure.
Thank you.
Can I just put two things on the record for your honor to consider while you're back there?
Sure.
CPS reports meet an exception to the hearsay rule, right? 803.8, they are public records and reports. They are sort of separately provided. They're kept by CPS in the course of its ordinary business as a state agency. Totally different than newspaper articles. 707 is the rule that governs using peer-reviewed articles. There is an entire rule about use of learned treatises which in Michigan is uniquely limited compared to the federal rules. And the rule specifically states that statements in published treatises, periodicals, or pamphlets on a subject of history, medicine, or other science or art, doesn't say newspaper articles, doesn't say investigative journalists, but then it goes a step further. It's not just that you find something in a learned treatise. It has to be established as a reliable authority by the admission of an expert. Only then can it be used on cross-examination. So we are so far afield here, they're attempting to use something that is not a learned treatise, not on cross-examination, that is not nearly as reliable as a peer-reviewed publication when the rules expressly state you can't do that for things that meet thresholds above. To the extent the argument here is weight versus admissibility, that's antithetical to what 702 says. And I would point, Your Honor, to the staff comment from 2004 amendment to Michigan Rule of Evidence 702. The new language of 702 requires trial judges to act as gatekeepers who must exclude unreliable testimony. So the idea that you just kind of like throw up your hands and say, we'll let it in, it goes to weight, is contradicted by what the rules require and is not permitted. You as the gatekeeper must find reliability, and the clear statements of 702, frankly, we would have filed a Daubert motion if we knew this was coming, but we're doing it now. It certainly does not meet the reliability. There is not a methodology that's generally accepted. And if we had known ahead of time, could have pointed Your Honor to a bunch of cases, but there is no methodology that's being applied here. There is no, what Mr. Asmussen said is Dr. Grubenhorst has specialized knowledge. Okay, that's the first step. It has to be applied using a reliable methodology in a way that's generally accepted within the field. None of that is happening here. Instead, we have Dr. Grubenhorst narrating and simply re-reporting what was said as a way to try to get the substance in, which is what our objection is, Your Honor.
Okay.
Thank you for the indulgence.
I'm going to stay right here. We'll just take 5 minutes to read the case. Mr. Asmussen, have you had sufficient time to review the case?
So, Your Honor, I maintain that from my reading of this case, what we have is an expert witness, Dr. Freed, who's relying on another therapist's statements to CPS. And so we have, just like in this particular case with the newspaper article, we have multiple levels of hearsay in that context. And there's a discussion that follows, and my understanding of the discussion that follows was defense counsel's choice in experts to rebut that testimony. And so to me, what we're looking at is a very similar situation to what we have here. I've asked for the expert's opinion, comparing this to other similar, potentially similar instances. The expert in that particular case, from my reading of it, relied on hearsay within hearsay at the very least, if not a couple more layers of that.
Wasn't In re Casto a ineffective assistance of counsel claim though?
It was. But my reading of this, and I apologize because you kind of, it's almost a rabbit hole, because that was not the defense. The issue was ineffective assistance of counsel by defense counsel, and that was not defense counsel's expert. Defense counsel had Henry as their expert, and so the expert Freed, it appears the defense counsel wasn't taking into account that this information could come in through Freed, and did not have another expert lined up to address that.
My understanding, and I could be incorrect because I did just read this in the last 10 minutes, but my understanding is that in this ineffective assistance of counsel case, Dad's new expert wanted to review the reports and the expert testimony, not even testimony, the expert reports that were, thank you, that were produced in the underlying case that they were being reviewed in, and that's where the evidentiary issue came up.
I'm sorry, can you say that again? I apologize.
That when we're talking about the hearsay within hearsay, it's a ineffective assistance of counsel claim in a termination of parental rights, and the dad's new expert wants to review the expert reports of the experts that were involved in the termination proceedings to see if there was ineffective assistance.
Well, but again, that doesn't negate the statement there that It's well settled that an expert may rely on hearsay evidence when formulating opinions. And my understanding is that it's the Dr. Freed's reliance on those hearsay statements that was allowed to come in.
Any further argument?
Your Honor, I think that with regard to Rule 703, 703 is the one that we're talking about. We're not attempting to rely on 707 in any way.
Okay. I am ready to make my ruling from the bench. I think that the rules of evidence that are applicable are 401 and 402 for relevancy, as well as 702 and 703 in expert opinions and the bases for those opinions. Particularly 702B states that an expert's opinion must be based on their testimony must be based on sufficient facts and data. And when looking at sufficient facts and data, while it is true that experts may rely on hearsay, I don't think that they can rely on hearsay within hearsay. The article at issue is a newspaper article that has been published by the New York Times. And I don't think that there is sufficient, having reviewed the article, I don't think that there is sufficient indicia of reliability of the content and the factual presentation in that article for it to form sufficient facts and data to form the basis of the expert's opinion. Specifically, I think that the article is anecdotal, it is not a learned treatise, and it is not a peer-reviewed study, which is usually what forms the basis of a expert's opinions or a fact, or it's not established by a fact witness, and it's not through a learned treatise or a peer-reviewed study. The information in the article, at least based on my reading, is not specific to Michigan. It's anecdotal. There is no analysis or comparison of the issues that are raised in the article with any other modalities of treatment providers, such as urgent care clinics, offices, doctor's offices, hospitals, etc. One example that came into mind, just to illustrate the anecdotal nature of this, I think the article criticizes a flooding that happened in a Planned Parenthood hospital or a Planned Parenthood clinic. However, I think that recently in the news, I've seen that there has been flooding at Duke University's hospital as well. So I don't find that the facts and data in this article, which are hearsay within hearsay, are sufficient or meet an indicia of reliability to form the basis of the expert's opinion. So I'm going to strike, and I'm not going to admit the article, and I'm going to grant the plaintiff's motion to strike the testimony that is based on this article.
Great. Just a couple more questions, Your Honor, and then I'll be done.
Okay, thank you.
Dr. Rubenhurst, we talked a lot about that newspaper article a few minutes ago. Your prior testimony that we talked about was not based on that newspaper article or any other article, correct?
Objection, the testimony's been struck, so seems now Mr. Benson is trying to get around the ruling that Your Honor has made.
No, I'm not. I'm just confirming that the only thing that she relied on that article for was that testimony that has been struck.
So, Steenberg, I don't know if you can help us out with this. Do you know, can we go back to a part in the testimony where you started talking about this article? You read the question right before it, because I would like everything after you started talking about this article up until any testimony from Dr. Rubenhurst to that point to be struck from the record.
I think that might take a little bit of time to do, but
if she can do it in like a minute or two, that'd be great. If not.
I believe the witness was testifying about advanced practice clinicians, and then that's when we took a turn into this article. Is that right, Mr. Benson? Yeah.
You know what? That might be too complicated to do. Mr. Atkinson, if you can just refresh, start with a new line of questioning, please.
Sure. Now, Dr. Woonhurst, you have worked with APCs in the past, correct?
Yes,
And you have trained APCs.
yes.
And your opinions regarding APCs providing abortions, were those provided in your expert report?
Yes.
And can you generally just summarize those opinions as you stated them in the expert report?
Yes, my opinion, as stated in the expert report, was that APCs do not receive either didactic or hands-on training, which is sufficient for them to perform abortions, especially given the need to manage potential complications of abortion.
Your Honor, I honestly think that I have exhausted my questions at this time.
Okay.
Thank you, Your
Very
Honor.
much. Okay. Dr. Rubenhorst, you need a break? Or are you okay to continue? You could use a break. Okay, let's all take a 10-minute quick recess and then we will reconvene.
Thank you, Your Honor.
Thank you.
Dr. Wubenhorst.
Good afternoon.
So you understand I represent the plaintiffs in this case, right?
Yes,
You and I have met, actually.
we have in the Texas dismemberment case in 2018.
It was actually 2017, but I deposed you and I examined you during that case, right?
Mhm.
And that case involved a law that restricted abortions in Texas, right?
Correct.
Right. And you were testifying on behalf of the state in that case, defending the law, right?
Yes,
Now, turning to this case, you have written a declaration and given a deposition. All of that was under oath, right?
correct.
All right, there's a binder in front of you that has a copy of your declaration and your deposition, as well as some other exhibits we might use during this examination today. And I may have some more exhibits as well, depending on how it goes this afternoon. Now, before we get started, before today, have you been watching the YouTube live stream of the trial?
I watched some parts of it.
So I want to start with your personal knowledge of abortion medicine. Dr. Wubenhorst, you have never performed an abortion, correct?
No,
And you've never received clinical training in performing abortion.
no,
You have never obtained informed consent from a patient for an abortion.
no,
And it has been 33 years since you personally observed an abortion.
Mm. I would have to estimate, but that sounds about right.
Right, and that was only once as a resident.
Yes,
Now, you testified on direct that you have treated patients with complications following abortion, right?
yes,
But you have only personally treated 4 patients with complications from abortion.
no, that's not correct.
All right, can you please turn to Plaintiff's Exhibit 103 in the binder in front of you? Now, this is, you sat for a deposition in the case in Texas that we just mentioned. This is the transcript from your deposition. Can you please turn to page 138, lines 9 to 14, and let me know when you're there. Question: have you ever managed a patient who is experiencing a complication from an induced abortion? Answer: yes. Question: how many times? Answer: probably 4 times. Now, Dr. Wubenhorst, in your career, you have treated hundreds of women with complications requiring childbirth, right?
Yes,
Now, you have never performed training for advanced practice clinicians in how to perform abortions, right?
I'm sorry. I think I need to clarify something here.
On the question I just asked?
No, on the previous question.
Well, Mr. Benson will have a chance to ask you clarifying questions when it's his turn to ask questions, all right?
Okay.
Okay. So to repeat my current question, you have never performed training for advanced practice clinicians in how to perform abortions, right?
No,
And you've never performed training for APCs on how to recognize and manage complications from abortion.
no,
You have never published a paper in a peer-reviewed journal relating directly to the provision of abortion, right?
can you define what you mean by directly?
Just what I said. You've never published a paper in a peer-reviewed journal relating directly to the provision of abortion, right?
Objection vague.
You testified earlier that you published a paper about abortion in Mexico, right?
Yes,
Other than that, no other peer-reviewed publications relating directly to the provision of abortion.
Objection. I think they have a different definition of abortion.
This is a direct quote from prior testimony that this witness has given.
I think it's within the scope of cross-examination.
I'm sorry. I don't remember the question.
Sure. You have never published a paper in a peer-reviewed journal relating directly to the provision of abortion.
If by the provision of abortion, you mean the actual performance of abortion, no, I have not.
Dr. Wubenhorst, can you make sure that, thank you.
Now, you testified earlier on direct that you have done tens of thousands of literature reviews, right?
Yes,
All right, can you please turn back to Plaintiff's Exhibit 231? Oh, I'm sorry, we haven't looked at that one yet, have we? Ah, okay. May I approach? All right, we were talking about that case in Texas. So if you could turn to Plaintiff's Exhibit 231, this is the trial testimony from that trial in Texas. So if you could please turn to page 66, lines 18 to 21, and let me know when you're there.
Yes.
Question: and approximately how many literature reviews have you done throughout your career? Answer: between 50 and 75, probably more than that, probably more than 100. Dr. Wubenhorst, you are not licensed to practice medicine in Chicago.
That wasn't a question, Your Honor.
Yeah,
That was impeachment testimony. It directly conflicted what she just said. She said earlier that she had done tens of thousands of literature reviews. And I just showed her testimony saying that she has done 50 to 75, maybe 100.
Can you ask her to refresh her recollection? And then if she still doesn't refresh her or change her answer, then have her read that testimony as opposed to you reading the testimony into the record?
Sure, Your Honor. I do believe it's a correct use of impeachment, but point taken. So you're looking at that testimony from Texas.
Yes.
Does this change the testimony that you gave earlier today that you've done tens of thousands of literature reviews?
It doesn't change it at all because, number one, at the time when I was answering this question, I was referring to literature reviews related to papers I had written. And also, this was in 2017. It's now 2025. I've done a substantial amount of research since then.
Thousands of literature reviews in the last 7 years?
Certainly because of the number of expert witness cases and because of papers, because of my reviews for especially the Inter-American Court case, I've done quite a few. But again, this specific, in context of this, the previous question you had asked in line 16 is that, have you done medical research? And how many literature reviews have you done? And that was referring to literature reviews directed towards my own medical research.
Dr. Wubenhorst, you are not licensed to practice medicine in Michigan, correct?
No.
You are not licensed? Is that, yes, you're agreeing with me?
You said, am I licensed? I said no.
I said you're not licensed. It's a tricky thing with the law.
Objection vague. Double negative.
Not vague, but please continue. It
Okay.
is a double negative, so.
Dr. Wubenhorst, you have not read and are not familiar with the licensing requirements in Michigan for physicians and advanced practice clinicians. Is that accurate?
That is correct.
You have not talked to any Michigan doctors about any aspects of their experiences in complying with the laws being challenged here.
I have not.
You have not talked to any Michigan patients about their experiences attempting to comply with the Michigan laws being challenged here.
I have not.
And over the last 25 years, you have worked at 25 different hospitals.
Well, I've been in practice longer than that.
That wasn't my question. You've worked at 25 different hospitals in the last 25 years. Is that right?
If you can show me my CV, I think I've worked at more than 25 now.
Your CV is in evidence, so it's all right. Now, you've worked at many hospitals in North Carolina, right?
Yes.
That's where you live.
Yes.
And you currently work at a hospital in Indiana.
Yes.
But you still live in North Carolina.
That is correct.
And you don't have any current positions in North Carolina that are listed on your CV, right?
That's correct.
Now, you've also worked at 10 different professional and academic institutions, including Duke.
I would have to see my CV under oath. I don't want to misrepresent the information.
Sure, that's about right, though. Sound about right?
I would need to count.
Okay, well, it's in evidence, so. Now, you were on the tenure track at Duke, yes?
Yes,
But you were not granted tenure at Duke.
that's correct.
According to your CV, you are currently a senior fellow at the D. Nicola Center for Ethics and Culture at Notre Dame, right?
Yes.
And your CV says that you have been since 2021.
I have been a senior fellow, but I've been a fellow of the De Nicola Center since about 2011.
So you don't actually appear on their website as a fellow. Do you know why?
Not all the fellows are on there, but I'm a permanent fellow.
Well, your position at Notre Dame was actually a 2-year fellowship that ended in 2023.
My official paid position was, but I continue on as a fellow. I use the resources of the center as a Notre Dame affiliate.
So your current position is an unpaid one.
That's correct. It's, as I said, it's a permanent fellow, but it is not a paid position.
And your position at Notre Dame doesn't involve clinical work.
No,
You don't work at their medical school.
they don't have a medical school.
Fair enough. Now, Notre Dame also has a Vita Institute that's part of the Center for the DeNicola Center for Ethics and Culture, right?
It is an annual event that is put on by the DeNicola Center.
And you're listed on that website as a past fellow, right?
I don't know. I haven't looked at the website recently.
Doctor, can you keep the mic close to you? Thank you.
Sorry.
If you can hear yourself, that's great.
For the record, this is Plaintiff's Exhibit 349. And it says past Vita faculty members include, and that's your name written in underneath there, right?
That's my name, but I want to bring to your attention the fact that this is referring to Vita faculty members. And what that means is people who spoke at the Vita. It is not related to my position as a fellow at the DeNicola Center.
Now, in your position at the DeNicola Center, you provide input into policy briefs, do research, and speak at their meetings, right?
Yes,
And you have contributed to their policy briefs supportive of a pro-life policy.
I have contributed to those. I've had other responsibilities as well.
The DeNicola Center is the most prominent and energetic locus at Notre Dame for pro-life teaching and research, right?
I would have to say that's hearsay. I'm not aware of that specific statement.
I'm reading it from their website, but do you agree with that characterization?
I haven't read it, and so therefore I can't agree with it or disagree with it.
You can't agree with the characterization, just sitting here today with what I just said.
I haven't seen it, so how can I agree with it if I haven't read it?
Did you hear what my question was, though?
I did, but I haven't read it for myself, so I can't reach a conclusion on that.
All right, well, the DeNicola Center is also committed to sharing the richness of the Catholic moral and intellectual tradition. Do you agree with that characterization?
Objection 610. This is an attempt to impeach based on potentially religious beliefs, and that's inappropriate.
Your Honor, I'm not asking about her religious beliefs. I am not asking about anything that would touch on her personal religious and moral foundation. However, I do have a lot of questions today that go to the witness's bias, which, there's plenty of case law saying that it is always permissible on cross-examination of an adverse witness to pursue facts that may bear on a witness's bias. And I can give you the citation for that. That's Detroit Wayne Company Stadium Authority versus Drinkwater. That's 267 Mish App, 6/25/2005. And I'll just note that, it looks like this objection might come up a lot in response to some of the questions I've had here. It's certainly black letter law that you, as the trier of fact, and the decider of law, must look at the credibility and discount or reject some or all of the witness's testimony. And so any questions that go to the witness's potential bias would be relevant to that evaluation. And I would also note that this witness, as she's testified to earlier, has testified in a number of trials around the country and has been asked and allowed to answer nearly identical questions.
I think that the bias and credibility of this witness is very relevant to the trial, and I will allow it.
So I'm going to ask my last question again.
Please do.
The DeNicola Center is committed to sharing the richness of the Catholic moral and intellectual tradition. Do you agree with that characterization?
I think that that is what the DeNicola Center says about itself.
So I want to turn to your opinions in this case. It is your opinion that for a patient to give informed consent to abortion, they must review fetal imagery from conception to 28 weeks, regardless of the gestational age of the patient's pregnancy.
Yes?
I would state it in a more nuanced way than that. I would state it in a more nuanced way than that.
Well, let me ask this. For a patient at 8 to 10 weeks seeking a medication abortion, is it important in obtaining informed consent from the patient that the patient be advised that a fetus at 28 weeks may have eyelashes?
To the extent that informed consent involves patient education, I think that it is very helpful for women to understand the spectrum and the continuum of development, fetal development.
So Dr. Wubenhorst, it was a yes/no question.
I think that a more nuanced answer is required.
So you understand that you know how to testify. You've done this before, right?
Objection, argumentative.
I don't think it's argumentative. I think having Dr. Wubenhorst and I have met before, and I am trying to establish that I'm going to be asking her yes/no questions. And to move this along, I'd really like her to give yes/no answers. So I'm trying to establish what the ground rules here are for cross-examination.
And the ground rules are that the witness needs to answer accurately and truthfully, Your Honor.
I'm going to allow the witness to answer the questions as she sees fit. If it goes outside the scope of what your cross-examination question is, I will allow you to kindly curtail it and then move on to the next question. But I think that I allowed a lot of leeway in the cross-examination of all the witnesses and the expert witnesses, and partially that's for my own edification. So I'd like her to give the answer that she needs to for.
So your answer, I believe, was it's more nuanced than that. Is that right?
Yes.
All right. Can you please turn to your deposition in this case, which is back in the first binder, Plaintiff's Exhibit 55. So it's going to be in the other binder, I think. So Plaintiff's Exhibit 55, page 87, lines 17 to 22, and let me know when you're there. Question.
My number again?
Sure, 17 to 22. Question. For a patient at, say, early pregnancy, let's say 8 to 10 weeks, who is seeking a medication abortion, is it important in obtaining informed consent from that patient that the patient be advised that a fetus at 28 weeks may have eyelashes? Answer, I think it is. Now, Dr. Wubenhorst, you aren't aware of any peer-reviewed papers that make such a claim?
No.
And based on the literature, suction aspiration or vacuum aspiration can be used safely and effectively up through the 16th week of pregnancy.
Yes.
Now, in this case, you didn't cite to any studies in your declaration that link the provision of fetal images with improvements in patient decision-making, correct?
Where are you specifically referring to?
I'm just asking.
You said this. Where are you referring to?
No, in this case.
Oh, in the case. Okay.
Yes. So in this case, you submitted a declaration, correct?
Yes.
All right. And in that declaration, you didn't cite any studies that link the provision of fetal images with improvements in patient decision-making, correct?
I did not.
All right. But after your deposition, lawyers for intervening defendants sent us a citation to a study that you had omitted from your declaration that you believe supports this opinion, and that's the Gator study, Gatter.
Can you provide that study? Because I want to be truthful.
Sure.
Yeah.
Yes.
At this point, I'm searching. So it's Plaintiff's Exhibit 107 is the Gator study, Gatter. Now, Dr. Wubenhorst, this study is titled Relationship Between Ultrasound Viewing and Proceeding to Abortion, right?
That's correct.
Now, at the beginning of the abstract under objective, the second sentence reads, let me know when you're there, the abstract. It has been speculated that ultrasound viewing will dissuade women from having an abortion. We examine whether viewing the image is associated with choosing to continue the pregnancy. Have I read that correctly?
Yes.
So it doesn't look at this is not research about patients who were asked to view images of fetuses like a fetal development chart. This is their own ultrasounds, right?
I think what the point that I was making here is that viewing an ultrasound has similarities to viewing fetal development charts. And in particular, that women's likelihood of choosing to take their pregnancy to term was strongly correlated, if I'm remembering this correctly, with the gestational age.
Now, the authors of this study caution against exactly the kind of conclusion that you're trying to draw. So let's look at page 5 together. It's 5 of the PDF, page 85 of the study. First column, second line. Unlike the 2 existing studies on the effect of ultrasound viewing, our analyses show that voluntary viewing was associated with some women's decision to continue the pregnancy. However, the effect was very small and should be considered with caution and limited to the 7% of patients with medium or low decisional certainty. Have I read that correctly?
Yes.
All right, now continuing on page 5, the second column, second sentence, and it continues on to page 6. Quote, in the highly politicized field of abortion care, opponents of abortion have promulgated the idea that the majority of women will opt to continue a pregnancy once they view their ultrasound images. In our study, however, 98.4% of patients proceeded to termination after viewing. From both a healthcare and policy perspective, it is important to understand the role that ultrasound viewing may play in women's decisions. It is equally important not to overstate its effects above other factors women use to make abortion decisions. Have I read that correctly?
You have, but I think that I would go down to the next paragraph where it talks about the increase in odds of continuing a pregnancy associated with each category of gestation age after 9 weeks, compared with pregnancies less than 9 weeks of gestation, suggests that women's comfort terminating their pregnancies decreases as gestation advances. This is a statement that the authors are making.
Your Honor, I move to strike everything after you have as non-responsive. My only question was if I'd read that correctly. If Mr. Benson wants to ask her more questions about this study on redirect, he's more than welcome to do so.
Your Honor, the witness is under oath and needs to answer the question in the way that she believes is truthful.
I've been allowing the witnesses a lot of leeway in terms of answering the questions, but your answer does need to be responsive to the question. So if there is more nuance and more in the study, I am sure that your counsel will get that from you and in redirect.
Dr. Rubenhorst, it is your opinion that for patients seeking an abortion, continuing the pregnancy is an alternative to abortion that should be disclosed to them, right?
Yes.
Thus, continuing the pregnancy should be offered to pregnant patients that present at an abortion clinic. Is that your opinion?
Yes.
And that's why every patient seeking an abortion should review materials about parenting and adoption, regardless of their stated goals for the pregnancy. Is that your opinion?
Yes.
So is it also your opinion that abortion should be offered to patients that presented an OBGYN for prenatal care for a wanted pregnancy, because for them, abortion is always an alternative to continuing the pregnancy?
I haven't considered that question. I can't answer that.
Dr. Rubenhorst, in this case, you haven't cited to any studies on the effectiveness of a one-day mandatory waiting period and allowing patients to gather financial support for pregnancy, correct?
I'm sorry, can you repeat the question or make it a little simpler?
So in this case, you haven't cited to any studies on the effectiveness of a one-day waiting period and allowing patients to gather financial support for continuing their pregnancy.
No.
And you testified earlier that it is your opinion in this case that most women are coerced into abortions.
No, I think what I said exactly is that research suggests that in most abortions, women experience coercion of some sort.
Well, in support of that opinion that you just gave, you cite to Reardon 2023. Is that correct?
Yes,
Should we look at that study?
sure.
Okay, so that is Plaintiff's Exhibit 249.
Yes,
Now, the Reardon study was a response to the Turnaway study. They mention it right there in the background of the abstract. Is that correct?
yes,
And the first line in the methods section of the abstract says, a retrospective study was completed of 1,000 females aged 41 to 45 living in the US. Is that correct?
yes,
And this study relies on patients self-reporting their memories of past abortions.
yes,
Now, the authors here, they didn't report the participation rate.
that's correct.
So of the 1,000 people who completed the survey, 226 reported a history of abortion. Is that correct?
Yes. Well, can I just look at the study for a
Sure.
second?
It's on page 1 in the results section of the abstract, and then also on page 4.
I'm actually looking at the methods, so if you can give me a moment, that would be great. So, yes, I'm looking on page 4. And what it says is to obtain a total of 1,000 completed surveys, a total of 1,161 persons identified by CINT, which is a survey marketing organization, to be females in our age range, responded to a survey invitation that did not reveal the topic. The first 2 pages contain only demographic questions, which were used to disqualify 122 respondents based on their self-reported age or gender. Of the remaining 1,039 respondents, 248 reported a history of abortion, which closely matches the Guttmacher Institute's estimate that by the age of 45, 23.7% of American women will experience an induced abortion. Of the 248 reporting a history of abortion, 226 completed the survey.
Now, can you look at page 4 with me? In the results section, second paragraph, at the end of the first sentence, the authors say 10% of those 226 patients described their abortions as coerced. Have I read that correctly?
Yes.
And then on page 3 of the study, if you can look at the first paragraph under table 1, the authors say that the survey question related to coercion asked participants, was your pregnancy, quote, coerced and contrary to my values and preferences? So there was no way for participants to indicate that their abortion was contrary to their values and preferences, but not coerced, right?
Yes.
Now there's no limitations section in this paper. Is that correct?
I would have to look and see. Yeah, there is a limitation section. It's on page 8 where it says.
I see the paragraph. Yes, it says another limitation. Is that what you're looking at?
No, up above, it says.
One strength?
One strength of our study, and then it goes down to say another limitation of our study is that Black women, low-income women, and it goes on. Then it goes on to another paragraph which describes limitations.
And in those 2 paragraphs, the authors also criticize Answer, who did the Turnaway study. Is that correct?
I was not paying attention to that specific issue.
Dr. Can you please make sure?
Sorry, I was not looking at that particular issue when I was reviewing this paper.
The first author of this study, David Reardon, He works at the Elliott Institute, which is a pro-life research group. Is that correct?
Yes.
And this study, it was published in the journal Curious, which is spelled Cureus, right?
Yes.
And if you look at the first page of the study in the top left, Curious is an open access journal. Is that correct?
Yes.
Dr. Wubenhorst, are you aware that Curious has been described as a predatory journal for practices including poor transparency about the peer review process?
That's hearsay and I can't comment on that.
Are you aware that Curious published an article with the results of a COVID trial that had previously been retracted by another journal for possible violations of medical ethics and human rights?
Retractions are not uncommon in academic articles and in academia.
Now, I want to show you another study that you relied on or that you cited for your opinions about coercion. It's the Moore study, and that's Plaintiff's Exhibit 241. Now, looking at the abstract, the second sentence.
Sorry, which exhibit are we on?
Sure, Plaintiff's Exhibit 241. Should be in the binder you have there. Looking at the abstract, the second sentence, the Moore study says that it only collected information from women with a history of intimate partner violence. So it says, quote, "We gathered full reproductive histories of 71 women ages 18 to 49 with a history of intimate partner violence." Did I read that correctly?
Yes.
Now, among these intimate partner violence survivors, there were reports of both coerced abortions and what the study calls pregnancy promotion, which is defined there in the abstract, let's see, as, quote, "male partner attempts to impregnate a woman, including verbal threats about getting her pregnant, unprotected forced sex, and contraceptive sabotage. Once pregnant, male partners resort to behaviors that threaten a woman if she does not do what he desires with the pregnancy." Have I read that correctly?
Yes.
And then looking at page 6 of Moore. This is in the discussion section. The second column, there's a paragraph starting recent legislation. And there, the authors explicitly pointed to laws penalizing only coerced abortion and said, quote, "The one-sided emphasis on only penalizing partners and healthcare providers involved in coerced abortions does not adequately address the danger a woman is in who is experiencing reproductive control." Have I read that correctly?
I don't see where you are, ma'am. Can you show me where exactly, or tell me where exactly you are?
Sure. So it's the second column in the discussion section. In the middle of the page, there's a paragraph that starts recent legislative efforts.
Okay, I see that now.
All right. Have I read that sentence correctly?
Yes.
Now, earlier on direct, Dr. Wubenhorst, you mentioned a study by Glander,
Yes,
and that study was published in 1998.
that's correct.
In this case, you haven't cited to any studies on the effectiveness of a 24-hour mandatory waiting period in reducing regret over a decision to have an abortion. Is that correct?
That's correct.
You also haven't cited to any studies supporting your position that a 24-hour waiting period is shorter than the typical preoperative process that OBGYNs and other physicians work within. Is that correct?
I think that if you recall my testimony, I was basing that on clinical experience. I really doubt that there are any studies on that particular question.
Now, Dr. Wubenhorst, you believe that women who have abortions have an increased death rate compared to women who carry their pregnancies to term. Is that correct?
I would restate that as there is research to suggest that the death rate is higher for women who undergo abortion than for women who carry to term.
So let's look at one of those studies. So if we look at Plaintiff's Exhibit 235, this is a 2002 article by David Reardon, again, as well as Priscilla Coleman. And this is data collected from California Medicaid recipients.
Yes.
Now, again, looking at the abstract, the methods section, the study looked at these California Medicaid records from, quote, women who had an induced abortion or a delivery in 1989. So that was over 35 years ago. Is that correct?
That's correct.
And then the study tracked those women for the next 8 years for deaths from all causes. And so that would include things like accidental deaths, violent deaths, etc.
Yes.
So this study would include a death from a surfing accident that happened 8 years after an abortion. Is that correct?
It could.
Dr. Wubenhorst, are you aware that the lead author, David Reardon, who we've talked about a couple times already, his graduate degree is from an unaccredited university that has since closed?
I can't speak to that. That is hearsay.
Well, are you aware that his co-author, Priscilla Coleman, has said under oath that Dr. Reardon is not good at statistics and too political?
Your Honor,
Again,
objection, this is hearsay.
I'm
He's asking if she knows. I'll allow it.
She's attempting to testify.
I'm just asking if, the witness is aware of that statement.
I'm not aware of that statement. And again, it's hearsay.
Okay. You testified earlier about complications from abortion.
Yes.
And in support of those opinions, you have cited to a study by Ninamaki that looked at data from Finnish patients from the early 2000s, yes?
Yes.
But you did not compare this data to Michigan data because they're completely different sampling frames and methodologies. Is that correct?
That's correct. I'm sorry, can you clarify what you mean? Which studies would I be comparing?
Ninamaki to Michigan data.
Yeah, I don't think that you could make a comparison because the structure of the Scandinavian National Health Service databases is such that patients enroll essentially at birth and are in the database till they die. We have no comparable databases in the United States.
So comparing complication rates in that Ninamaki study to actual numbers in Michigan would have been an inappropriate comparison. Is that correct?
I think that you could use that as a baseline estimate, but I would, in order to identify the potential numbers of complications, but I think that it would be difficult.
Doctor, is it possible to pull the microphone closer to you so you don't have to keep leaning in?
I'm
Maybe
trying, yes,
pivot it?
I'm trying to balance like
Yeah.
this and
Okay, I see.
yeah. Mhm.
Dr. Wubenhorst, you're aware that the authors of the Ninamaki study have warned against interpreting their research the way that you are right now.
I'm aware of their letters and I'm aware of the the letter that they sent to a journal identifying. However, I am taking what they published at face value in terms of the complications they've identified. And it's one of the few studies that we have that is able to look at this question.
So let's look at that response that the authors have submitted. That's Plaintiff's Exhibit 239. Now on page 2, the third column under in reply, I think it's the second sentence, the authors say, quote, "It is important to keep in mind that the study is registry-based, not a randomized study with strict protocols and definitions. Thus, many of the complications are not really such, but are rather concerns or adverse events that bring women back to the healthcare system. Such consultations result in diagnoses in the registries. These limitations are discussed in the article. Have I read that correctly?
Yes.
You testified earlier about an association between surgical abortion and preterm birth.
Yes.
Now, one of the studies, well, actually, let's look at that study. So this is Plaintiff's Exhibit 236. It's a study by Lemmers et al., and the title is Dilation and Curettage Increases the Risk of Subsequent Preterm Birth, a Systematic Review and Meta-Analysis. So the study question here was about D&Cs for miscarriage and termination of pregnancy. Is that correct?
Yes.
Now, you've testified that you consider yourself a researcher and that you have experience in medical research. Do you know that an association is not the same thing as causation?
Yes, I'm aware of that. I would like to, excuse me.
Dr. Blumenhorst, there's no question pending. Again, if Mr. Benson wants to ask you more questions about this study, he's more than free to do so.
Okay, I thought that I had latitude to explain my answer.
Does your answer have to do with, was it association versus causation?
Yes.
Okay, then I'll let you answer.
Then proceed. Apologies.
So if you look down under wider implications of the findings, it says the increased risk in association with multiple D&Cs indicates a causal relationship.
D&Cs, right? That's what this study's about.
It's about D&Cs for either miscarriage or abortion. So therefore, what they are saying is with multiple D&Cs, they are suggesting a causal relationship.
Dr. Blumenhorst, you testified earlier about the effect of abortion on mental health symptoms. And informing that opinion, you cite to a study by Rue, Coleman, and Reardon again, right? Is that correct?
Are you referring to my expert report?
Yes.
Could you put it in front of me possibly?
Sure. So it's in the first binder. It's Plaintiff's Exhibit 30. Page 17. So your declaration is Plaintiff's Exhibit 30, and I'm referring to page 17, the second and third paragraphs.
Yes.
That study relies exclusively, well, you rely on that study and you cite that study in your expert report and you rely upon it for your opinion, correct?
My opinion regarding what?
The mental health effects of abortion.
No, I think that specifically what I'm talking about here is screening for coercion. Because I said that in the second paragraph, a 2004 study that surveyed women who had undergone abortions in the US showed the importance of waiting periods, increased counseling, and in-person visits in order to screen for coercion and ensure informed consent. Then I go on to talk about the fact that the women in the study felt that they did not receive adequate counseling and what they reported. I don't opine on mental health effects here.
You cite a statistic about how many women felt badly about their decision.
I'm quoting from this study, but the fact that women felt badly about their decision is something that is stated in the National Abortion Federation guidelines and elsewhere. So I'm not opining on mental health. I am simply pointing out that this study showed that these, I was referring to the study, let me back up here a little bit. This is showing the importance of counseling and the fact that women said that they did not receive adequate counseling. And the fact that they felt pressured, were uncertain about their decision, had health complications, or felt badly about their decisions is simply getting at the point that there were emotional outcomes related to this. I don't opine on the mental health outcomes.
Let's take a quick look at the study.
Okay.
So if you turn to page 3, under materials and methods, and then there's a header that says participants.
Yes.
The second sentence in that paragraph says data were collected in 1994 at US and Russian healthcare facilities. Have I read that correctly?
Yes.
Dr. Wubenhorst. Before I move on, did I put on the record the exhibit number? I don't think I did. Plaintiff's Exhibit 240 was the ruse study. So, Dr. Bubenhorst, you have also provided opinions in this case about the standards for counseling patients for abortion. When counseling a patient, it is important for the physician to understand the patient's context. Is that correct?
Yes.
And tailoring information to a specific patient means that a medical provider should take into account any medical issues and comorbidities that the patient may have and attempt to address the patient's concerns. Is that correct?
Yes.
Obtaining proper informed consent to some extent involves taking into account the specific circumstances of the individual patient.
Are you quoting my previous testimony?
I am.
Okay, can you show that to me?
Sure. So I believe it's in the first binder that you have in front of you. Plaintiff's Exhibit 220. You sat for a deposition in a case in Kansas. That case also involves regulating informed consent before abortion, and this is the transcript of your deposition from that case.
Yes.
So I'll direct your attention to page 143, lines 16 to 19, and this is a little confusing because it's 143 of the deposition, but 144 of the Bates stamp.
Yes.
All right, so lines 16 to 19. I'll ask the question again. Obtaining proper informed consent to some extent involves taking into account the specific circumstances of the individual patient. That's correct, right? That's your testimony right here.
Maybe I'm in a different spot, but in line 16 says.
Well, hold on, let me come over and
The
if
question.
I have permission, I'll make sure you're
Sure,
in the right
that's
place.
fine. Mhm. You said 143, that's 143. And you said line 16. But this is a question.
Yeah. Answer.
Right. But I wasn't asking the question. The way you're phrasing it, it sounded like I was asking the question.
Want me to repeat my question?
Yes.
Okay. Obtaining proper informed consent to some extent, in your opinion, involves taking into account the specific circumstances of the individual patient. That's your opinion.
Yes.
If a physician is communicating information that is truly irrelevant to a patient's circumstances, you believe that can violate the patient's autonomy.
I would have to think about that question. I think that my response would be that we want to avoid paternalism in assuming what is relevant or what is irrelevant. So I would have to really consider that question.
All right, so can you look on the next page of that transcript? It's page 145 by the numbers at the top. lines 10 to 14. Question: if a physician is communicating information that's truly irrelevant to a patient's circumstances, that can violate the patient's autonomy. Answer: I think it can. Dr. Wubenhorst, if a physician gives incorrect information to a patient, that also has the potential to violate a patient's autonomy. Is that correct?
Yes.
Now, you testified earlier about some NAF clinical guidelines,
Yes.
but you can't speak to whether following the 2024 NAF clinical guidelines for informed consent would be sufficient to obtain informed consent from a patient. Is that correct?
I think that the NAF clinical guidelines are just that. They are not informed consent documents and they are not prescriptive.
You testified earlier that not all clinics are NAF members, something to that effect.
Yes.
You're not a NAF member.
No.
Never have been.
No.
I'm going to turn to your opinions in this case related to advanced practice clinicians or APCs. You agree that the number of patients receiving medical care from APCs in this country is increasing, and that includes pregnancy-related care. Is that correct?
Which testimony are you referring to?
I'm actually not at this point. I'm just asking if you agree that care from APCs is increasing in this country. You testified earlier that you yourself work with a number of APCs in your current practice.
I seem to recall that being a question that I was asked in deposition. So that's why I'm referring to that.
Mm-hmm. Well, let me ask you this. The bodies that are involved in licensing APCs in Michigan, that's outside your area of expertise.
That's correct.
And until plaintiff's counsel alerted you, you were not aware that APCs in Michigan provide miscarriage management. Is that correct?
That's correct.
And you understand that the physician-only rule, it doesn't limit the physicians who can provide abortion only to physicians who are board certified and trained in OBGYN, correct? Is that correct?
If you had the law, I would like to confirm that. If we can look at, you're referring to the law. So if you can show me the law, then I can confirm, reinforce my remembrance of it, because I don't want to say the wrong thing under oath.
I think we can move on.
Okay.
And you testified earlier that procedures to treat miscarriages are very similar to abortion procedures.
They are.
The medical instruments for both are very similar, if not
Yes.
identical.
Yes.
Now, in support of your opinions on APCs in this case, you've cited to a survey by Foster of APCs from the year 2001 and earlier.
Yes. Do you have that study here?
Sure do.
Oh, okay.
For the record, this is Plaintiff's Exhibit 237. You cited to this study, is that correct?
Yes.
So on the second page, the second column under data collection, the last two sentences of that paragraph, quote, subsequent non-respondents were faxed the survey on several occasions from the summer of 2000 through the fall of 2001. All surveys returned to the NAF office by the end of 2001 are included in this analysis. Have I read that correctly?
Yes.
So you have not cited to any peer-reviewed publications with data from after 2001 that perform a survey about the availability and scope of training or education for APCs in the United States.
No, I have not. To the best of my knowledge, there was not any there were not any contemporaneous studies unless I have not seen them.
Moving on, as I mentioned earlier, you and I met when you gave testimony in Texas.
Are you done with this study,
I am.
Counselor? Okay.
Now, you've also testified in a lawsuit on behalf of the state of Kentucky in defense of a Kentucky law restricting abortion.
Yes.
You've testified in a lawsuit on behalf of the state of Indiana in defense of an Indiana law restricting abortion.
Yes.
You testified in a lawsuit on behalf of the state of North Carolina in defense of a North Carolina law restricting abortion.
Yes.
You testified in a lawsuit on behalf of the state of Kansas in defense of a Kansas law restricting abortion.
Yes.
We talked about the Texas law. That was in 2017.
Yes.
You also provided testimony in another case in 2001 related to a heartbeat ban in Texas, but you didn't disclose that to us before you gave this testimony here, did you?
I wasn't aware that I was told that that case was not going to proceed, so that was why I did not include it. So that was if that was something I should have included. I wasn't trying to hide anything. I apologize. My understanding was that the action didn't go forward. I'm not a lawyer.
Fair enough.
But I did not provide a deposition or trial testimony.
This is a good clarification, actually, because earlier you testified about being involved in 7 cases. But to be clear, you didn't testify in 7 cases and provide trial testimony and then become an expert formally in front of a judge in 7 cases. It was actually 3.
This is a legal thing that I just am not aware of.
Let me ask it this way.
Yes.
You testified in court in Texas,
Yes.
Indiana,
Yes.
and Kentucky.
Yes.
So those are the cases where you were tendered as an expert and accepted by the courts.
When I said earlier that I was an expert, what I was saying was that I provided expert witness testimony in the form of a written report. I am not a lawyer and I don't understand the distinctions.
You also testified in a lawsuit in Colorado where you provided the opinion that progesterone can reverse a medication abortion.
No, that's not what I said.
You testified that progesterone can antagonize the effects of mifepristone in a woman who changes her mind about having a medication abortion.
So if I can be very precise with terminology, what I said was that progesterone can be used to antagonize the effects of mifepristone when mifepristone was given as the first step in medication abortion.
You also testified, you mentioned this earlier, before the Inter-American Court on Human Rights in a case out of El Salvador.
Correct.
That case involved a young woman named Beatrice who was carrying a baby with anencephaly who was seeking an abortion.
Correct.
And you testified against Beatrice and gave the opinion that she had no medical indications to undergo an abortion.
I'm not sure that I would use the idea of testifying against her because she's deceased. I would say that I was asked to provide expert testimony regarding whether there was a medical indication for her to have an abortion while she was pregnant with her child who had anencephaly.
And your opinion was that there was no medical indication?
After reviewing the chart, yes.
Anencephaly is a fetal condition where the baby is born without parts of its brain or skull.
Correct.
Most babies with anencephaly die within minutes, hours, or days.
Correct.
Now, you testified earlier about renal agenesis.
Yes.
And a couple other fetal diagnoses where I believe your testimony was about advances in surgery for some fetal diagnoses.
Yes.
Do you recall that? Now, there are certainly lots of other serious or fetal diagnoses that affect whether or not the baby will be born and survive the pregnancy and live for any sustained amount of time. Would you agree with that?
I mean, all of them are born. The question is when they are born, how long their lifespan is. So
Some are
perhaps
very short.
some are short, yes.
You believe that abortion of children with anomalies is eugenics in its purest sense.
Yes.
You have compared abortion for anencephaly to Nazism.
If you can show me where I did that, I don't believe I made that statement. So please show me that.
Yeah, so it's in binder 2, which might be the one that's closed. So plaintiff's exhibit 227 is testimony you gave before Congress on the topic of abortion. And you were under oath when you gave that testimony to Congress. So if we look at page 17, I'm sorry, you were under oath when you gave testimony before Congress?
Yes.
Yes, all right. If you look at page 17, the bottom of the page.
Sorry, which exhibit are we on? I'm just trying to follow along here.
Sure, plaintiff's exhibit 227, it's in binder 2.
Thank you.
Page 17, again, the bottom of the page. This argument that the rights and dignity of human beings does not matter because they were going to die anyway was used by the Nazis and others as they attempted to justify horrific experiments on and abuse of their victims. That was your testimony.
It was, and I am not saying that the termination of children with anomalies is the same as Nazism. Nazism was a philosophy. It was a political and military movement. So I'm really not making that connection at all, Counselor. I'm merely pointing out that the motivation to regard some individuals as not being worthy of life is something that is common to a eugenic mindset that says that you should terminate children with anomalies. But I am not making a direct comparison to Nazism. I want to be very clear on that point.
You believe that the disproportionate rates of induced abortion in the Black and Hispanic communities are evidence of this eugenic mindset.
Can you show me where that is?
Yes, also in Plaintiff's Exhibit 227. So we're in the same paragraph, I believe. I apologize. I seem to have the wrong page number. Give me one moment. All right, I think it's on page 3. Oh. All right, page 9. Sorry about that. Ah, there we are. The paragraph starting the unborn child. Quote, the same eugenic mindset that led to the sterilization of African Americans, Native Americans, and Hispanic women continues in the disproportionate rates of abortion in Black women and the rising rate of abortion in Hispanic women. That was your testimony.
Yes.
You have also stated that the so-called right to abortion does not exist because it requires the violent destruction of a human being, thereby violating their rights.
Yes, I have said that, and that is in the context of international treaty documents which do not identify a right to abortion. And these are treaty documents to which the United States is a signatory.
You understand that in Michigan, there is in fact such a right to abortion?
And I mentioned that in the initial direct examination, that I understand that and that that is the law here.
Sorry.
Sorry. Yes, I understand that and that that is the law here.
So back to this case for a moment. You testified earlier that the state of Michigan is paying you $800 an hour for your work on this case. That was leading up to trial. Is that correct?
Yes.
And then the state of Michigan is paying you $3,900 for a half day of trial, double that for a full day. So that would be $7,800.
Yes.
Are you charging the state for the time you spent traveling here last week?
I haven't thought about it. Since I did not appear in court, I haven't thought about it.
All right, moving on. I want to talk about some of your general opinions about abortion. You believe that an unborn child is a human being at all stages of gestation.
That's correct.
And you submitted an amicus brief in the U.S. Supreme Court in connection with the Dobbs case.
Yes.
And in that brief, you supported overturning Roe v. Wade.
Can you show me that testimony?
Absolutely. So if you turn to Plaintiff's Exhibit 55.
Okay, I have it.
All right, so page 70, lines 3 to 5.
Sorry, was this exhibit 55? Which binder are we in?
Binder number 1. So page 70, lines 3 to 5. Does that refresh your recollection?
Yes.
So in that amicus brief you submitted in Dobbs, you supported overturning Roe v. Wade.
I think that the specific, my understanding as I was answering that question was that the purpose of it was in support of Dobbs itself. And since I didn't give direct testimony in terms of, since I gave testimony here saying that it was my understanding that the purpose, one of the things that Dobbs would do would be to overturn Roe v. Wade. And so I think that a more accurate way of looking at this was that my understanding was that I was filing, participating in the filing of a brief for Dobbs, and Dobbs would have the effect of overturning Roe v. Wade.
Yeah, your name was on the cover of the brief. It said brief of Monique Giroux-Wubenhorst.
There were 3 of us who put the brief together.
You testified earlier.
Actually, that's not correct. There were 4 of us.
You testified earlier that you're a member of the American Association of Pro-Life Obstetricians and Gynecologists, or APLOG.
Yes.
APLOG is an organization that's opposed to abortion.
Yes.
You previously served on APLOG's board.
Yes.
APLOG medical practitioners share the view that human life begins at fertilization and the lives of preborn children should be protected.
Yes.
You were on the board for Americans United for Life.
Yes.
Americans United for Life has a mission of using legal strategies to promote a culture of life.
I don't know what their current legal strategy is. I resigned from the board almost 4 years ago. At least 3 years ago.
So plaintiff's exhibit 55, if you still have it, can you turn to page 49, line 4 to 7? Answer, insofar as I can remember, because it's been a few years, I believe that the mission of the organization was to promote a culture of life by using legal strategies.
Right, and that's
Doc-
just what I said. It's
Doc-
been a few years. I don't know what their mission is now.
In January 2023, that was last year, you spoke at an event during the March for Life in Washington, D.C.
Which event was that? I'm sorry.
The event was titled Building a Civilization of Love, a roundtable discussion about constructing a post-Roe world in which mothers, babies, born and unborn, and families are protected and cared for as they deserve. That event is listed on your CV.
Yes.
What year was this?
That was 2023.
Last year.
No, it's 2023. It wasn't last year.
That was
Or
2
2
years
years
ago.
ago? Ah, okay.
Yeah, that was
Apologies.
why I couldn't remember. Go ahead.
Sorry, 2 years ago. You recall?
Yes.
All right. And that was associated with the March for Life in Washington, D.C.
No, it was associated with the DeNicola Center.
Okay, can you turn to Plaintiff's Exhibit 347? Oh, you know what? It's in the smaller binder here.
Oh, okay. Thank you.
Page 340, Plaintiff's Exhibit 347. This is a web page from the DeNicola Center where you're a fellow. And at the top of the page, it says March for Life 2023. And then in schedule of events below, there's your event.
I mean, just because it was during the March for Life, I've never attended the March for Life, and I did not attend it during this particular year. I attended the roundtable discussion, and that was it. So I can't really speak to that. I wasn't even really aware at the time that it was during the March for Life.
The DeNicola Center at Notre Dame, where you're a fellow, or were a fellow, dedicates funding to student and faculty participation in the March for Life in Washington, D.C.
Can I clarify that I am a fellow at the center, please? I'm a permanent fellow, as I've said at least twice.
Okay.
Thank you.
So the DeNicola Center at Notre Dame dedicates funding to student and faculty participation in the March for Life in Washington, D.C.
Is that here?
You can look at Plaintiff's Exhibit 346.
Yes, I see that.
In 2023, you wrote an article for the Carolina Journal entitled, I am one of many OBGYNs in North Carolina who supports protecting unborn children.
I'm sorry, Counselor, can you go back to your previous question where you were talking about the DeNicola Center? I'm not understanding what you were asking me about the March for Life.
Yeah, so the second sentence there says the center maintains 4 dedicated restricted funds earmarked for 1, general pro-life programming, 2, student and faculty participation in the March for Life in Washington, D.C., 3, the Notre Dame Vita Institute, and 4, the Notre Dame Evangelium Vitae Medal.
So what's the question?
I was just asking if you were aware that the DeNicola Center dedicates funding, where you're a fellow, dedicates funding for student and faculty programming at the March for Life in Washington, D.C. every year.
I was not aware of that.
So again, in 2023, you wrote an article for the Carolina Journal entitled "I am one of many OBGYNs in North Carolina who supports protecting unborn children." This is listed on your CV.
Yes.
In that article, you wrote, quote, "An African proverb says, in any abortion, one person is killed, another is injured, and a third gets paid." You wrote that in that article?
Yes.
It is your hope that abortion as a solution becomes unthinkable, for it has already done Black women, their children, and society immense harm.
Is that a question?
Do you believe that?
I believe it based on objective data, and I think Michigan is actually an excellent example of that. Black women comprise 7% of the population here, but have 58.5% of the abortions.
And you wrote about that in an article for Newsweek where you again cited to the Reardon study about California Medicaid recipients that we discussed earlier.
Can you show me that article?
Plaintiff's Exhibit 303.
Okay, we are close to almost 4 o'clock.
So close.
I don't want to
Okay.
interrupt you at a point. Do you have a couple more follow-up questions based on this question? And then
I do have a few more pages,
how about,
so maybe we should stop.
yeah, let's adjourn for the day and pick up with cross-examination again tomorrow.
Okay.
Before we adjourn, are there any other matters that we need to discuss? Oh, I'm sorry. Dr. Rubenhorst, you are excused for the day. Oh, thank you very much. Thank you.
Thank you, Your Honor. I don't know if we need to address and resolve this now, but there is the
Keep
question.
your appearance on the record again, just to make the.
Sorry
record
about that.
clear.
Christopher Braverman on behalf of Director Marlon Brown. There is the question of which testimony is specifically being stricken from the record that I think could impact some of the named defendants' potential questions for Dr. Wubenhorst. So whether we address that maybe first thing in the morning or discuss outside, maybe amongst the parties, I don't know if you have a preference, but the answer to that question will influence if certain questions will need to be asked.
For the plaintiffs, Your Honor, totally agree. Thank you for raising Mr. Braverman. We have been getting the transcripts. I suspect, I'm looking at Lauren, we probably won't get it until tomorrow morning, has been our usual time. So my suggestion, we typically get them at like 10 a.m. That perhaps once we're finished with Dr. Rubenhorst, before we start with Dr. Curlin, if we're able to get the transcript, maybe the attorneys could confer before we start, see if we can reach an agreement based on the final transcript before we dismiss Dr. Rubenhorst and try to address it that way. I'm just thinking about timing, but I totally agree with the suggestion and would want to make sure we were clear too.
Mr. Asmussen?
I mean, I'm happy to take a look at the transcript.
Okay, does the timing of that, do you have any objections to that or?
We can do our best, Your Honor.
Okay, sounds good.
Thank you.
Thank
We'll
you.
address it in the morning.
Sounds good. Any other issues before we adjourn for the day?
Not for the plaintiffs. Thank you, Your Honor.
Not for the defense, Your Honor.
Okay, thank you very much. We are adjourned for the day and I will see everyone here at 9 o'clock tomorrow.